Good morning, everyone. Okay, I have to make an observation. We were observing over here. The first two rows are completely empty. And everyone's packed in the back there. Just so you could spread out a little if you wanted. and maybe we'll call upon those in the first two rows. No, I'm just kidding. So, okay. Good morning, everyone. My name is Garnet Hanley, and I'm Chief of the Competition and Infrastructure Policy Division of the Wireless Bureau. For those unfamiliar with our organizational structure, the division supports compliance with the National Environmental Policy Act and the National Historic Preservation Act, as well as the environmental notification process required for the antenna structure registration system. These are all topics that we are pleased to have the opportunity to review with you today. I'm pleased to welcome everyone, both those in person and those participating virtually. Before we start with our first speaker, I would like to go through a few housekeeping matters. Given this is a hybrid event with both in-person and online participation, I would like to note to everyone that we have some speakers who will be presenting in person and those who will be presenting virtually. So we have a lot of material to cover today. It's a very packed day. And I imagine many in the audience will have questions. So once each panel concludes their presentations, we will leave some time at the end for questions and answers. We have several hundred participants today, so we cannot guarantee we will get to all the questions, but we will do our best in the time allotted. I ask that you send all your questions via email to fccenvironmentalworkshop@fcc.gov. It's at FCC Environmental, ENVIRONMENTAL, workshop, WORKSHOP, @fcc.gov. We also ask in-person attendees to email their questions to the same email address, FCC@fcc.gov, because it might be difficult for those online to hear the questions. Also, you'll note there are a few signs in the room with the Wi-Fi code in case the in-person participants are having trouble accessing their email. Also, for in-person participants, we've confirmed there's no food permitted in the room, so I encourage everyone to keep that in mind for the 45-minute lunch break. I would also like to thank here Carrie Hicks, the Deputy Bureau Chief of the Wireless Telecommunications Bureau, and John Lockwood, Senior Legal Advisor for the Wireless Telecommunications Bureau, for helping us with the questions and answers portion of several panels today. And now, I am pleased to introduce Joel Tabenblatt, the Bureau Chief of the Wireless Telecommunications Bureau, to provide some introductory remarks. Thank you, Joel.
Thank you, Garnet. Good morning, everyone, and welcome to this important workshop on the FCC's environmental and historic preservation rules, policies, and procedures. Today, you will hear throughout the day from experts from the FCC on how we implement these rules. I also would like to welcome experts from our fellow government agencies, the Advisory Council on Historic Preservation, the National Telecommunications and Information Administration, the White House Council on Environmental Quality, and the U.S. Fish and Wildlife Service. We're grateful for their participation today as well. And like Garnet, I'd like to thank all of you for attending, both those who are here in person, as well as the many folks that we have online today. We really appreciate the opportunity to collaborate with all of you on doing our best to facilitate the deployment of wireless services that can benefit the American public, and also making sure that that deployment is done in a way that helps to protect and preserve our environmental, historic, and archaeological resources, including tribal cultural resources. I would like to thank the FCC staff who planned and prepared this workshop, including our technical staff back there who makes these events in the Commission meeting room possible. I would also like to express my thanks to the FCC's infrastructure team for their tireless work in managing environmental and historic preservation issues here at the agency. I hope that you find today's workshop informative and educational. And I think with that, I will turn things back to Garnet to kick off our agenda. Thank you very much. Have a great day.
Thank you again, Joel. Okay, and now I'm pleased to announce our first panel on environmental rules and enforcement overview. Allison Jones, the Associate Chief of the Competition and Infrastructure Policy Division of the Wireless Bureau, and Shannon Lipp, Assistant Division Chief of the Spectrum Enforcement Division of the Enforcement Bureau, are here in person. And Daniela Arugi, Attorney Advisor of the Enforcement Bureau, will present on these topics virtually. And so first, I'm going to hand it over to Allison. Thank you, Allison.
Okay, so hopefully everyone can hear me. Just turn my microphone on. Anyway, my portion of today's program sets the stage by providing a high-level overview of how the NEPA and NHPA rules apply to infrastructure deployments. My colleagues will then discuss certain aspects of the rules in more detail. So first, what is the National Environmental Policy Act, or NEPA? NEPA, which was originally enacted in 1970, requires federal agencies to consider and disclose the environmental effects of their actions to improve decision-making and encourage transparency, public participation, and accountability. It requires agencies to integrate environmental considerations into their decisions and establish a process for environmental review. NEPA is a procedural statute intended to ensure federal agencies consider the environmental impacts of their actions in the decision-making process. NEPA does not mandate particular results or substantive outcomes. All major federal actions significantly affecting the environment trigger environmental review. NEPA establishes 3 levels of review: categorical exclusions, environmental assessments, and environmental impact statements. Next slide, please. So what are the types of activities that require FCC environmental review? Building new towers, modifying towers, or co-locating antennas on existing structures requires compliance with the FCC's rules for environmental review. Towers requiring antenna structure registration are also subject to environmental notice rules to provide the public an opportunity to identify potentially significant environmental concerns. The FCC's environmental review rules ensure that entities constructing facilities to support FCC licensed services take appropriate measures to consider environmental and historic resources, and that the agency meets various statutory obligations. So this umbrella graphic depicts the rules and regulations that are associated with the environmental review process. Those rules include NEPA, FAA rules, the Migratory Bird Treaty, the Clean Water Act, the National Historic Preservation Act, including Section 106, the Endangered Species Act, the Wilderness Act, and floodplains management. Next slide, please. The FCC meets its NEPA obligations by imposing enforceable duties on licensees and applicants through its environmental rules. The rules apply to all licensees, applicants, registrants, and owners of facilities used for FCC licensed services, such as commercial licensees, utilities, and public safety entities. Tower owners that are neither licensees nor applicants must also follow these rules if they intend to host antennas supporting FCC licensed services. The FCC delegates the initial assessment of potential environmental effects and the determination of whether categorical exclusions apply to applicants constructing facilities to support the use of FCC licensed services. So what do the FCC's rules say? Sorry, next slide. Yes. The FCC's NEPA rules categorically exclude from the preparation of an environmental assessment most commission actions with respect to new applications or minor or major modifications of existing or authorized facilities or equipment. However, actions that are not categorically excluded include facilities that involve high-intensity lighting or that cause human exposure to RF emissions that exceed the limits in the Commission's rules, and actions that trigger site-specific location considerations that are spelled out at Section 1.1307 of the rules. The NEPA checklist tool, available on the Commission's tower and antenna siting webpage, assists applicants in identifying when an EA is triggered under Section 1.1307. My colleague, Paul Dari, will describe the NEPA checklist later in more detail. In addition, the responsible bureau may order an EA when an interested person alleges that an otherwise categorically excluded action will have a significant environmental effect. Also, the Bureau may order an EA on its own motion. Next slide, please. So Rule Section 1.1307 identifies those circumstances where an EA is required. Facilities that require an EA include facilities that are to be located in an officially designated wilderness area or an officially designated wildlife preserve, facilities that may affect listed, threatened, or endangered species or designated critical habitats, or are likely to jeopardize the continued existence of any proposed endangered or threatened species, or likely to result in the destruction or adverse modification of proposed critical habitats. Also included are facilities that may affect historic properties that are listed on or eligible for listing in the National Register of Historic Places. Also included are facilities that may affect Indian religious sites, facilities to be located in floodplains if the facilities will not be placed at least 1 foot above the base flood elevation, facilities whose construction will involve significant change in surface features, facilities that are to be equipped with high-intensity white lights that are to be located in residential neighborhoods, and facilities that would cause human exposure to RF emissions that exceed the Commission's standards. Next slide, please. So this slide shows the FCC's NEPA process decision tree. First, the applicant should determine whether an action may have a significant environmental effect. If no, the applicant should retain documentation of environmental review to be produced upon FCC request. If the answer is yes, then the applicant would prepare and file an EA. The EA then goes on public notice for 30 days. The Commission reviews and accepts public comments during that period. If issues remain, the applicant must amend their application to reduce, minimize, or eliminate environmental concerns or prepare an EIS. If no issues are identified after substantial comments are addressed, the FCC issues a finding of no significant impact or FONSI. And note here at the bottom, regardless of an applicant's determination, the FCC may order an environmental review of a facility pursuant to a request made by an interested person or on a Bureau's own motion. Next slide, please. I will now talk briefly about the Endangered Species Act and migratory birds. First, with respect to endangered species, applicants must consider the impacts of proposed facilities on sensitive species and their habitats, including communicating with the U.S. Fish and Wildlife Service. With respect to migratory birds, applicants must prepare an EA that considers the effects on migratory birds when a proposed antenna structure will be over 450 feet above ground level. My colleague Paul Dari and Joel Gehring from the Fish and Wildlife Service will discuss these requirements in more detail. Moving on to the National Historic Preservation Act, or NHPA. The FCC's NEPA rules also ensure that the agency meet its statutory obligations under the National Historic Preservation Act. Section 106 of the NHPA requires federal agencies to consider the effects of federal undertakings on historic properties. The FCC is a party to 2 nationwide programmatic agreements that establish Section 106 reviews tailored to new tower construction and co-location projects. Applicants are delegated the responsibility for initiating the Section 106 review process for proposed facilities. The Commission maintains 2 databases, the E106 system and the Tower Construction Notification System, or TCNS, to facilitate communications with relevant parties. The NHPA and the FCC's MPAs require consultation with any federally recognized tribal nation that attaches religious and cultural significance to historic properties that may be affected by an undertaking. Applicants notify tribes of proposed projects using the TCNS system. My colleagues Ellen St. Ange and Christine Heacock will discuss the Section 106 process later in more detail. Now for antenna structure registration. Towers that meet certain criteria require notice to the Federal Aviation Administration and the FCC's ASR system. This includes towers more than 200 feet above ground level and towers that are located near an airport or otherwise create a potential obstruction to air safety. The FCC's ASR rules require a tower owner to notify the FAA and receive a final determination of no hazard prior to registration. ASR applicants must complete an environmental notification process unless an exception applies or a waiver is granted. Interested persons may submit a request for further environmental review of a proposed facility in ASR, and all such submissions are publicly accessible. And as noted at the bottom here, we will discuss several times today the fact that applicants may not begin construction until the ASR process is completed and any environmental concerns are resolved. My colleague, Mike Smith, will discuss the ASR registration process in more detail. And finally, a brief overview of how NEPA and NHPA apply to small wireless facilities. The Commission has streamlined the NEPA and NHPA review processes for small wireless facilities. Small wireless facilities generally qualify for NEPA's categorical exclusion for co-locations found at 47 CFR 1.1306 Note 1, subject to certain exceptions. In addition, the 2001 nationwide programmatic agreement for the co-location of wireless antennas excludes from Section 106 review most small wireless facilities that are not on or near historic properties or historic districts, subject to certain exceptions. The Commission has also excluded from Section 106 review the replacement of a utility pole, where the pole was not originally constructed for the sole or primary purpose of supporting an antenna for an FCC licensed service, subject to certain exceptions. My colleagues Sarb Sharbra and Robert Krinsky will discuss small cells and the exclusions associated with these facilities in more detail later. Next slide, please. The last thing I wanted to highlight was the FCC's tower and antenna siting webpage. This webpage provides a great deal of useful and relevant information, so I encourage everyone to become familiar with that webpage. And that concludes my portion of today's presentation, and I will now turn it over to our colleagues in the Enforcement Bureau, Daniela and Shannon.
Good morning. My name is Daniela Reggie. I'm an attorney at the Spectrum Enforcement Division within the Enforcement Bureau. I will be discussing the enforcement of the environmental rules. We wanted to start off with providing some examples of NEPA and NHPA compliance violations. If we could turn to that first slide. Now, an example of a NEPA NHPA compliance violation is commencing construction prior to completing the environmental review and review requirements. And this includes any ground disturbance prior to the completion of those requirements, including, if applicable, the Commission's issuance of a finding of no significant impact, which is commonly referred to as a FONSI. And some of these environmental review requirements were addressed by Allison, and these include the applicable NEPA and HPA checklists, the Clean Water Act obligations, any obligations for wetlands or floodplains, the NHPA, which includes Section 106 and the tribal review and consultation, as well as any obligations under the Endangered Species Act. Other compliance violations include failure to register a tower prior to construction within the Commission's antenna structure registration, the ASR system, failure to complete any requested archaeological monitoring during construction, failure to submit the environmental assessment, otherwise known as the EA, when triggered by an environmental checklist, and failure to complete any required mitigation that may be required for the construction. It's also important to note that tower builders and owners are responsible for any violations that could be caused by its subcontractors or consultants. Next slide, please. And here we wanted to illustrate the three main phases of an Enforcement Bureau investigation. There's the initial complaint or referral. Once the Enforcement Bureau receives that initial complaint or referral, we will gather additional information and we'll conduct an investigation and look into those potential violations. Once that additional information has been reviewed, then the Enforcement Bureau will determine whether it will pursue an enforcement action or if it will close the investigation. Next slide, please. And here we wanted to illustrate the various sources of NEPA and NHPA complaints. And as you can see, the sources vary, and it's both the Wireless Telecommunications Bureau and the Enforcement Bureau that receive complaints. The Wireless Telecommunication Bureau may receive complaints directly from tribal historic preservation officers, state historic preservation officers, or the public, and will then refer the matter to the Enforcement Bureau for further review. The Enforcement Bureau receives complaints from the public, government referrals, or it can commence an action sua sponte. With respect to government referrals, there are a variety of entities that may refer a matter to the FCC, and this can be government agencies, state, federal, inquiries from Congress that can reach out directly to the Enforcement Bureau or to one of the commissioners. And then with respect to investigations that are commenced sua sponte, this may be due to a news article or another source that leads the commission to investigate a matter, even if we haven't received a formal complaint. Next slide, please. Within the Enforcement Bureau, the Spectrum Enforcement Division will review and investigate a complaint or referral to determine whether it alleges a potential NEPA or NHP violation under the Communications Act or the Commission's rules. And an Enforcement Bureau investigation is separate from any WTB, or Wireless Telecommunications Bureau proceedings. So it's important to keep that distinction that there are proceedings within the Wireless Telecommunications Bureau, but that's entirely separate from any enforcement action or investigation that's conducted within the Enforcement Bureau. If a violation is found, the Enforcement Bureau may enter into a consent decree with the target of the investigation. It may issue a notice of apparent liability for forfeiture and ultimately a forfeiture order with a monetary fine, or in some rare instances, it may resolve the investigation with a non-monetary action. Next slide, please. When an investigation is warranted, the Enforcement Bureau may issue one or more letters of inquiries to a target. A letter of inquiry is akin to a commission order. Therefore, the recipient is required to respond timely, truthfully, and completely. The letter of inquiry will advise of the apparent rule violation or violations at issue and seek information and documents regarding the event, the extent of any harm, and the target's actions. And before filing a response to the letter of inquiry, a recipient must preserve relevant records, conduct any needed internal review, and if necessary, contact the Bureau with any questions regarding the letter of inquiry or any filing requirements. When necessary, the Enforcement Bureau can also issue a letter of inquiry to a third party with knowledge of the matter. We may depose a witness in person, conduct field inspections, or refer criminal matters directly to the Department of Justice. Next slide, please. Here we wanted to illustrate the various enforcement pathways, which are categorized in three areas: a citation, a consent decree, the notice of apparent liability for forfeiture order, which then ultimately becomes the forfeiture order. And starting with the citation, this is a non-monetary action. So there are some tower owners that are not commission licensees. So the citation will be a warning to a non-licensee that they are subject to the FCC rules. And next, a consent decree. This is a negotiated settlement agreement between the target of the investigation and the commission. A consent decree will require a mandatory compliance plan as well as an admission of liability of any of the violations at issue. And then we have the notice of apparent liability for forfeiture and a forfeiture order. These orders will detail the violation through the information that we've gathered through the course of the investigation. The NAL, the notice of apparent liability for forfeiture, this will propose the monetary fine. The forfeiture order is the final enforcement act, and that will order the fine to be paid directly to the U.S. Treasury. Next slide, please. Now we wanted to start off with the notice of apparent liability for forfeiture, commonly referred to as the NAL. This is a charging document, and it gives the party notice of the violations at issue. If an investigation reveals a violation of the Communications Act, a commission order, a commission rule, or terms of an authorization, the commission may impose a fine by issuing a notice of apparent liability for forfeiture. Now, this NAL provides the target with notice of the alleged violations, as well as the maximum penalty that could be imposed, and provides the target with an opportunity to respond or contest the allegations. Once the NAL has been issued, a target has 30 days to either one, pay the proposed monetary fine disclosed in the notice of apparent liability for forfeiture, or it can contest the facts and law that are alleged, or otherwise explain why it believes that the monetary fine amount should be reduced. Next slide, please. And this is the kind of the main distinction between a forfeiture order and an NAL. The NAL proposes the monetary fine. The forfeiture order imposes that fine, and the fine becomes a debt that's due to the U.S. Treasury. The Enforcement Bureau will review any responses to the notice of apparent liability that are filed by a target. However, in the absence of a settlement via consent decree, the Commission will generally issue a forfeiture order that imposes the full amount of the notice of apparent liability, or it could impose a lesser amount. In some very rare instances, the FCC may dismiss the NAL. It's important to note that forfeiture orders may be appealed. However, if a target does not pay a fine, the fine that is imposed in the forfeiture order, the matter is referred to the Department of Justice for collection in federal court. Next slide, please. And here we have the consent decree. A consent decree is a settlement of the violation, and it's typically resolved faster and with less expense than a notice of apparent liability, because both the target and the Commission are agreeing and negotiating the terms of the consent decree. Once it's executed, the consent decree will terminate the investigation or any future forfeiture proceeding. It's important to note, though, that generally the Enforcement Bureau will not pursue a consent decree if a party has not come into full compliance. So, stated otherwise, a consent decree is generally not an available resolution until a party is in full compliance of all of the Commission's rules. The consent decree will require an admission of liability to the violations at issue. And it also requires a multi-year compliance plan that's designed to prevent the recurrence of the type of violation at issue, as well as a payment of a civil penalty. And this is usually less than what would be imposed in a notice of apparent liability. Next slide, please. We wanted to provide in this workshop some best practices. It's important to implement proactive measures to prevent violations and ensure compliance in the first instance. Therefore, it's important for companies to regularly review and update policies, trainings, and the NEPA checklist. It's important to document, authorize, and review each element of the project and carefully review subsequent modifications. And this is important for construction projects that may have modifications down the road in order to ensure that the initial proposed construction complies with all of the environmental rules, but as well as any subsequent modifications are also in compliance with our rules. And finally, we also kind of wanted to highlight the importance of training in order to ensure that all employees and subcontractors adhere to NEPA and HPA procedures that specify the federal requirements and timelines. We can't stress enough to never start construction prior to completing the required environmental review and the required Tribal Historic Preservation Officer and State Historic Preservation Officer notifications. Construction includes any excavation, any clearing of brush, any cutting of trees. So it's important that the site is left untouched, that there is no construction until all of the required environmental reviews have been concluded. It's important to engage with the affected Tribal Historic Preservation Officers and State Historic Preservation Officers throughout the process and do more than the minimum of following up to any electronic Section 106 notification and to respond to inquiries in a timely fashion. And again, this is also important with construction projects that may have modifications or changes down the line. a party should quickly notify both the Wireless Telecommunications Bureau and the Enforcement Bureau if you suspect a potential violation. In some instances, the Enforcement Bureau may consider reducing the amount of the fine for voluntary disclosure, but that's only if the matter is self-reported and disclosed directly to the Enforcement Bureau before an investigation is commenced. And then, as we stated before, it's important to respond fully to an Enforcement Bureau's letter of inquiry and to provide all supporting documentation. In some instances, even if there is no substantive violation found through the course of the investigation, the failure to respond completely can itself result in significant monetary penalties because, again, that letter of inquiry is a commission order. Next slide, please. And we wanted to kind of continue that preference of the best way to avoid enforcement is to comply with the rules. If anyone has any questions that are either fact specific, I wanted to refer any matters to the Enforcement Bureau. Here is a direct link to the Spectrum Enforcement Division. Our email address is eb-sed-response@fcc.gov. And I believe there's one additional slide. Again, if you have any questions, they should be emailed to the FCC Environmental Workshop at fcc.gov. Thank you.
Thank you, Daniela. So it looks like I do have one question here that I think is relevant for the audience. And Daniela and Shannon, I'm going to read it out, and I think maybe you might be able to answer this. It says, what are some of the most common environmental violations the Enforcement Bureau sees in this context?
Shannon, I can take that.
Oh.
So I think we stated this before in the beginning of the presentation. So applicants must comply with all the applicable environmental rules before construction commences in order to address and comply all of the NEPA and HPA obligations. Some of these examples were also discussed during the slide, and they include commencing construction before completing the required reviews, failure to complete the ASR registration process before construction, failure to complete archaeological monitoring, failure to complete any required mitigation or conditions that are set by the state or tribal historic preservation officers or any government agency, and failure to submit an EA when triggered by the NEPA or NHPA checklist.
Great, thank you, Daniela. So I have one question here I think is relevant to this discussion. What can an applicant do to bring a tower that has no documentation of completing environmental review pre-construction into compliance? And so it is the applicant's responsibility to maintain documentation of compliance. So please make this a priority. Unfortunately, the nationwide programmatic agreement does not establish a process or have a provision for post-construction review. If a SHPO and tribes are willing to participate in such a review, it may be possible to clear the underlying tower. If the consulting parties object, however, the tower unfortunately joins a very long list of non-compliant towers. Post-construction Section 106 clearance requires significant resources on behalf of both the Commission and the ACHP. The best answer that I can offer is that it is much better to follow the environmental rules from the start and to complete all required reviews prior to construction. Okay, so we have received other questions. They seem to be related to some of the other presentations that we're going to hear this afternoon, so we're going to hold off on some of those. And so I think I think that might be it for now. I want to thank everyone. Shannon, Daniela, and Allison, thank you. Okay, great. We're going to start our second panel, which will focus on NEPA, migratory birds, and endangered species. For our speakers, I would like to introduce Paul Dari. He's Senior Counsel for the Competition and Infrastructure Policy Division within the Wireless Bureau. And we have a guest speaker as well, Dr. Joelle Gehrig, biologist for U.S. Fish and Wildlife Services. And I'm just going to give Joelle a minute here. She's coming to the table. And thank you again, Joelle, for presenting in person today and taking time out of your day to come and join us. Paul is joining virtually. That is correct. Thank you again, Joelle. So first, as Joelle gets situated here, I'm going to hand it over to Paul, and he will be presenting. Thank you, Paul.
Thank you, Garnet. Good morning, everybody. So I'm going to cover...
Actually, Paul, can you yes. Turn up your volume a little bit or get a little bit closer to the microphone, just to make sure everyone can hear you?
All right. How about this?
Better. Thank you, Paul.
All right. So I'm going to cover NEPA checklist and the Commission's general categorical exclusion for wireless facility deployments. I'll also go over compliance with the Endangered Species Act, and I'll talk a little bit about migratory birds just before Joelle gives her presentation on towers and migratory birds. Okay, so I need to get the next slide. I think the next slide, right, isn't it? There we go. All right, so most proposed wireless facilities are categorically excluded, and an environmental assessment is not required except as provided for in the Commission's rules. This categorical exclusion is in section 1.1306A. It states that a proposed facility is categorically excluded if it does not trigger one of the factors in section 1.1307A1 through 8, and it would not cause human exposure to radio frequency emissions that exceed the Commission's limits pursuant to section 1.1307B. These rules, section 1.1307A and B, are commonly referred to as the NEPA checklist. And again, in general, if a proposed facility does not trigger any of the factors in section 1.1307A or B, it is categorically excluded. But there are exceptions where an EA will be required. If a categorically excluded project may nonetheless significantly affect the environment. If a member of the public submits a request for environmental review, alleging that a particular action that is otherwise categorically excluded will have a significant environmental effect, the responsible bureau may issue an order in response to the request requiring an EA pursuant to section 1.1307C. Also, again, for projects that are otherwise categorically excluded, the Bureau may order an EA on its own motion if it determines that the proposal may have a significant environmental effect pursuant to section 1.1307D. An example is the reference in the note to section 1.1307D provides that antenna structures that are over 450 feet and trigger other factors that will trigger an EA. And I'll cover this later in more detail. Next slide, please. Okay, so to determine whether a particular facility is categorically excluded, the applicant must determine whether it triggers any of the circumstances identified in the checklist. As Allison mentioned, a very good description of the process is on the Commission's Tower and Antenna Siting webpage, and it includes a link to the NEPA checklist, which the Commission staff updated last year. Next slide, please. Okay, so here's a screenshot of the checklist. Allison covered this in the previous session, so I'm not going to go over this again. Next slide. Okay. So complying with the Commission's environmental regulations requires a detailed analysis of each of the categories on the NEPA checklist and a determination as to whether there may be a significant environmental effect. This analysis must be completed prior to the completion of any associated applications, including the antenna structure registration form. And in all cases, this analysis must be completed prior to construction. And it is also important that the applicant retain documentation of its environmental review, including its checklist documentation, so that it can be produced upon request from the Commission. And you know, it's important to keep in mind that documentation must be retained regardless of whether an environmental assessment is required. As Allison and Daniela both discussed, an applicant must complete its environmental review prior to commencing construction. This means no grading soil, removing vegetation, clearing an area, or otherwise beginning construction. Also, if a request for further environmental review is submitted by a member of the public, construction cannot commence until after the Commission has resolved the matter. Next slide, please. All right, so an important part of the checklist analysis concerns threatened and endangered species. The Endangered Species Act provides a framework to protect and conserve endangered and threatened species and their habitats. The Fish and Wildlife Service maintains a list of threatened and endangered species, and applicants are required to determine whether threatened and endangered species and critical habitats are present at their proposed facility sites and assess what kind of impact they will have. Next slide, please. Okay, so section 1.1307A3 of the Commission's rules provides that an EA is required if a proposed facility may affect listed threatened or endangered species or designated critical habitats, or is likely to jeopardize the continued existence of any proposed endangered or threatened species, or likely to result in the destruction or adverse modification of proposed critical habitats. Applicants are required to notify the Commission and file an EA if any of these conditions exist, and this determination must be made by a qualified biologist. Next slide, please. Okay, so this is just a screenshot of the detailed instructions in the NEPA checklist for complying with the Endangered Species Act, and we advise all applicants to review these instructions carefully. Next slide, please. Okay, so there are 3 effects determinations under the Endangered Species Act. There's no effects for cases in which protected species are either not present or not affected, may affect, not likely to adversely affect, and may affect likely to adversely affect. Next slide, please. All right, so no effect means that either no listed proposed threatened or endangered species or designated or proposed critical habitats are present at the location of the proposed site, or species are present but would not be affected by the proposed antenna structure. So, for projects that do not require an EA, the applicant should document in its records how it ascertained that there would be no effect and retain materials that form the basis for this determination. And for projects that require an EA for a different NEPA trigger, the applicant must include in the EA an explanation of how it determined that there would be no effect, and it should provide the documentation to support its determination. Next slide. So if a project may affect, but is not likely to affect, not likely to adversely affect, listed or proposed threatened or endangered species, or designated or proposed critical habitats, the applicant needs to obtain a letter of concurrence from the Fish and Wildlife Service. This can be obtained. It can obtain the concurrence by submitting an informal biological assessment to the Fish and Wildlife Service. And for this purpose, we encourage applicants to use the IPAC system. IPAC can provide an informal biological assessment when an applicant enters the necessary information. And the applicant can then submit the informal biological assessment directly to the Fish and Wildlife Service to request concurrence without going through the FCC. Next slide. All right, so whether a project that may affect, not likely to adversely affect, requires an EA must be decided on a case-by-case basis. In general, an EA is not required if the Fish and Wildlife Service concurs with a may affect, not likely to adversely affect determination, and it does not impose any conditions on its concurrence. Conversely, an applicant must file an EA if the Fish and Wildlife Service issues a concurrence with conditions. Next slide, please. So a project that may affect, likely to adversely affect listed or proposed endangered species or designated or proposed critical habitats requires a biological opinion from the Fish and Wildlife Service. A biological opinion is a document that states the opinion of the Fish and Wildlife Service as to whether the project is likely to jeopardize the continued existence of listed species or result in the destruction or adverse modification of critical habitats. It provides measures to minimize the take of listed species, and it specifies the extent of take allowed. And it also provides for reasonable and prudent measures to minimize impacts, and as well as the required terms and conditions. Next slide, please. All right, so to obtain a biological opinion from the Fish and Wildlife Service, the applicant is required to prepare a biological assessment and submit the formal biological assessment to the FCC staff so that staff can initiate formal consultation with the Fish and Wildlife Service. And then the Fish and Wildlife Service will provide the biological opinion to the FCC. Following that, the applicant then prepares and files an EA, which will include the biological opinion and describe the formal consultation process with the Fish and Wildlife Service. and the requirements of the biological opinion. Next slide, please. Okay, so the FCC staff strongly recommends use of IPAC. It's a valuable tool that can significantly streamline the consultation process with the Fish and Wildlife Service. Here's a link to the IPAC tool, and a link can also be found in the ESA section of the FCC's tower and antenna siting webpage. Next slide. So, all right, so in a few minutes, Joelle will be making her presentation on towers and migratory birds. Before she does that, I'm going to briefly cover an EA requirement, which was adopted by the Commission in 2011 in response to concerns about the impact of towers on migratory birds. At that time, the Commission determined that a proposed tower that will be over 450 feet in height above ground level requires an EA if it involves new tower construction or modification or replacement of an existing tower constituted a substantial increase in size, or if the changes to a tower involve the addition of lighting or adoption of less preferred lighting style as defined in section 17.4C1 of the Commission's rules. Okay, next slide. Okay, so one final point. An EA may be required if proposed tower may otherwise significantly affect migratory birds, even if the proposed tower would be less than 450 feet. And to make this determination, applicants are required to complete the detailed checklist analysis of the proposed tower's impact on migratory birds. All right, so Joelle is now going to give her presentation on migratory birds. Joelle is an expert on migratory birds and towers, and we are lucky to have her today. I just want to point out that part of what she will be covering concerns changes to lighting on towers that the FAA made in coordination with the FCC. Joelle was the FCC's biologist when these changes were made, and she was very involved with the process. Joelle?
There we go.
You're on mute,
Thank you.
Joelle. Oh, yeah.
All right, now you can hear me better. Great, so thank you very much. It's always a pleasure to come back here, not only just to see my old friends, but to also be a part of this tower community. I've been working on the issue of bird collisions with towers for over 20 years now. So it's my son is 23, and he does not remember a day when we weren't working on tower stuff. So it's fun to be here. So if you could put the slides up, that would be great. And so let's talk about birds. We've seen a lot of text on the slides. It's a lot of very important stuff. And I'm going to try to show you some pretty pictures and talk about birds and how we can all be a part of bird conservation and saving money at the same time. So the next slide, please. So yeah, this is kind of an overview of what we're going to be talking about. We're going to be talking about how changing tower lights can reduce the costs that's incurred by the tower industry. It can reduce tower climbing, and we all understand the value of that, both for human safety and for cost. And we're going to talk about how this is directly correlated with bird conservation and how this process is a win-win for everybody and a pretty easy process. So next slide, please. This slide shows the increase in the number of bird-friendly towers that are on the landscape. Okay, this, Paul talked about how this change was made possible by the FAA in 2012, but then it really was incorporated into the FAA advisory circular on marking and lighting.
Into the FAA advisory lighting.
It was changed in 2012, but then it was incorporated into the advisory circular in 2015. And you can see it was after that point that it really started becoming more common on the landscape. There was only one tower like that before that. It was a special exception, a variance by the FAA in Michigan, actually. So next slide, please. So why does this matter? Well, you may have seen the news articles in 2019 of the loss of 3 billion birds in the last 50 years, since 1970. And so what does that mean? What is 3 billion birds? Well, it's a lot, but what does that mean? It's significant decreases in some birds that are relatively common. For example, the Baltimore Oriole. I mean, that's a team around here. You know, it's an important icon in the area, and it's also a bird that lives in our urban environments. And we've lost 2 out of 5 Baltimore Orioles since 1970. And that's a significant loss. A bird like the eastern meadowlark that lives in the grasslands, we've lost 75%. 3 out of 4 of those birds are gone. Why? Is it towers? It might be a part of the issue, but it's probably we know it's a lot of habitat loss. It's a lot of collisions with glass, like the building across the street is pretty glassy and lit up. You might have heard of the situation that happened early October in Chicago with the McCormick Place. That made a lot of headlines, and those are the issues that we're talking about. Birds colliding with lit structures, birds losing their habitat. Migration is tough, and these birds are incurring a lot of challenges along the way. So it's sad, it's pretty scary, and I focus exclusively on migratory birds now that I'm with the Fish and Wildlife Service, and we have a lot of work to do, and we're working hard every day with a lot of passionate people trying to get stuff done. And you guys can be a part of that. And so next slide, please. This is the hopeful stuff. When we know what to do and we do it, we can make a difference. Raptors, birds of prey, anybody who deals with eagles nesting on towers is like, yeah, they're increasing. And yes, they are, because we have regulated DDT in the environment and the birds are responding. We haven't done a whole lot else for bald eagles except take a lot of the toxins out of the environment, give them some space, and they've recovered. Waterfowl, the same way. Ducks, geese, people cared. They're hunters, cared. And people who care about water quality cared. And they said, we need to protect our wetlands. They're part of filtering our water. We need to protect our ducks because we like hunting them. And it's part of our culture. And so we protected habitats. And the ducks came back. So when we know what to do, and we work in partnership and we do it, we can make a huge difference. And this issue with communications towers is a piece of this puzzle for those songbirds that are migrating. So this is an overall, what are we talking about a little bit today? Why do we care? And now I'm going to dig into the weeds a little bit. Next slide. So I'm going to say 6.8 million birds per year in the US and Canada collide with communications towers. These are the birds we're talking about in steep decline. But I'm also going to point out, as Garnett pointed out to me, I think last year, this is from 2012. I would love to see an update on this, because you guys as an industry have made a lot of progress on reducing tower lighting. And we'll talk a little bit more about why that's important, but there's still progress to be made. So this is outdated, and it could be better now, and I'd love to find out. But what's happening here? So these are birds that are migrating from the boreal forest, from the greater DC area, and they're migrating all the way down to Central America, South America. That's a long ways. They do it a couple months after hatching from an egg, which that always baffles me. They are doing it without GPS, without MapQuest, if anyone remembers MapQuest. Like, they're doing it on their own with their DNA and their flock mates. They're using stellar constellations to figure out where they are. And I'll remind you that the Earth is turning, so those are moving throughout the night, right? That always baffles me. Like, how do you do that when they're actually moving? You know, it's quite impressive. So using stellar constellations, magnetic fields of the Earth, sunrise, sunset, landmarks like the Mississippi River, the coastal areas. They're keying in on those aspects of the Earth. Oh, there goes my sticker. To make their way all the way down, sometimes to the exact same shrub or tree every year. It's quite amazing. You'll have the same individual come back to the same nest structure. Like, how did you do that, you know? I need MapQuest or Google Earth, you know, to get anywhere I'm going. So it's very impressive. But along the way, they run into challenges. And even though they can make those long-distance migrations, they don't recognize glass as an obstruction. They don't understand that flying towards the light is not a safe thing to do. So next slide, please. So I was fortunate enough, and I truly consider myself fortunate enough to have worked on this topic for over 20 years. And we worked on a study in Michigan with the Michigan State Police Public Safety System Tower, MPSCS, and we looked at what are the variables involved in when a bird hits the tower and when it doesn't, because not every tower is involved in a lot of bird collisions. So we looked at weather we can't really control, but we did consider that in the study. The location in the landscape, you guys understand that you need a tower where you need it, and you can tweak it a little bit, but in general, there are some limitations. The tower's there for a reason and in that location. So there's some limitations on what we can do with where in the landscape it goes. Micro sighting, yes, but you know what I'm talking about. Like they need to be in certain areas. And then, but we can often control the tower support system. Is it guide or is it unguide? Is it a monopole? Is it a monopine? What does that structure look like? And how tall it is? I understand there are limitations on that, requirements for height, but the tower height is an important variable when it comes to bird collisions, so we wanted to look at that. And then tower lighting systems. There were, I actually saw letters to the FCC online somewhere that was like from 1970, and people saying, we think the lighting's involved. We think the birds are attracted into the lights. But we didn't have any good solid data. So we wanted to generate that in our Michigan study. Next slide. So we focused in on these last three variables. Those were things we could control and you as an industry can be involved in. Next slide. So we found that, and there is a typo on this slide, so I encourage you to listen to me. I found the typo this morning. And I got to say, if I worked at the FCC, they would have went over those slides very carefully, and I would have found it earlier, but I don't work for the FCC anymore. So there's a mistake, and I'll get to it, and I want you to just listen carefully. So we found in general that we had more bird collisions at the tall towers, towers that were guide versus self-supported, and towers that were lit with steady burning lights. Sometimes we call them side markers, sometimes we call them L810s, but it's the little lights. I think they're almost, well, sometimes they're LEDs, but I think most of the time they're incandescent. Little lights are literally about this big, 3 of them around a tower usually, and those are the ones that are attracting in the migratory birds, those non-flashing, steady burning lights. We saw fewer bird collisions at shorter towers, self-supported or unguided towers, and then there's the typo. We need to see fewer bird collisions at towers lit with only flashing lights at night. So hopefully I'm making myself vulnerable here, and you'll remember now. Flashing lights are good. Non-flashing lights or steady burning lights are those that are encouraging birds to fly towards them. We don't completely understand why, but it's a thing. Okay, so we want fewer. We see fewer bird collisions at towers lit with only flashing lights at night. Okay, next slide. So again, to emphasize that, we did an experimental study. This was all experimentally done, peer-reviewed, published in scientific journals. We found that we had 50 to 70% reduction in fatalities at towers that eliminated their non-flashing steady burning lights. So if the lights were flashing, only flashing, not just a combo, but like only flashing, those towers saw 50 to 70% reduction in the migratory bird collisions. And that's a lot. And if you think about the old number, 6.8 million birds, 50 to 70% of those birds, that's a lot of birds. It's millions of birds. Okay, next slide. So this is from the old advisory circular, before 2015. Okay, so these, you can see the only option to light a tower without steady burning lights was a white light system. And many of us know that that's not popular with the neighbors. It can be useful in some cases, but it's not popular with the neighbors. So a lot of the tower industry folks were going with the red flashing light systems, which always included a non-flashing light component or a steady burning L810. So in 2012, there was a conspicuity study that came out from the FAA that said, yeah, it's okay if you extinguish those non-flashing lights. But it was really until 2015 when the advisory circular was updated to incorporate that. Next slide. So this was in 2015. This is the cover of that one. Now we have a newer version, the M version, which has a prettier picture on the front, or an image. But this was the 2015 version, and then next click, please. And if anybody works in Canada, Canada made it an option to light towers in a bird-friendly way. So in 2015 and on, for us in the United States, we were required to use bird-friendly lighting systems. So eliminate those side marker lights, 2015 and on. In Canada, it's still an option to use those steady burning lights, but it's an option to light in a bird-friendly way as well. Does that make sense? Okay, next slide. Okay, so reiterating this point, the smaller one up at the left-hand corner, that's the old advisory circular. You can see those little nubs on the side. Those are the steady burning L810 side marker lights. And then we changed to the newer version on the right that extinguishes or eliminates those side marker lights. You don't even have to put them on the tower. And there is a little bit of an exception on those shorter towers, the 151 to 350. Those side marker lights are expected to flash, which we understand that L810 side marker lights were not really designed to flash. So an LED system is really where it's at for those shorter towers, 350 and below. So if you click it one more time, you'll see just a reminder. So this is for new and existing towers. So those towers on the landscape, you have that opportunity to make those bird friendly, to reduce your number of tower climbs, to reduce the energy that's going into those structures, etc. So the new towers are required. The existing towers that were on the landscape before that, it's encouraged by the FAA to extinguish those side marker lights. So again, new FAA lighting standards, extinguish non-flashing lights on towers. You don't have to remove them, just turn them off. And then for those towers taller than 350 feet above ground level, and reprogram them to flash on towers 150 to 350. We understand incandescent can't really be reprogrammed. That's my understanding. And that LED lights are the best option. And those can, under my understanding, can be reprogrammed to do just about anything. So well, I'm not going to get into details because you guys know these more than I do, but sometimes this can be done remotely. You don't even have to be on site to reprogram those LEDs. Next slide. So this is from our FCC, I think it's the Media Bureau webpage, but this goes through the detailed steps of how to do that. And in the back of the room, I've left about 30 copies of printouts of these steps, an FCC document at the back of the room. And so it's a pretty simple process. It's a pretty simple 3-step process. The first one is to get the FAA to let them know that you're interested in doing this. So you're going to be filing a Form 7460-1 and asking them to change your lighting system, to update it to the new advisory circular. And this is sometimes, for a lot of people, an intimidating step. I'm talking for tower owners, probably not necessarily people in this room, but some of the older owners of older broadcast towers, this is a big deal to get online, remember your password, and to ask for this step to occur. And I think that's what holds people up a lot and stops them from saying, I have other things I need to be doing, other lower hanging fruit. This is not a priority. But this is an important first step. We need to make sure it's okay with the FAA that these lights are extinguished on the side as the side marker lights. And I'm only aware of a couple situations where it has not been approved. But it's just a process. I think I've heard it goes a lot faster than if you're starting from scratch with a new tower. It's just an updating of lighting on an existing tower. So that's the first step. It can take 24 hours. It can take a little bit longer. I encourage you to reach out to me if you're running into problems and not hearing back from the FAA. And I know a lot of the people in the FAA field offices, and I'm happy to just give them a ring and say, hey, is there anything we can help you with to get this moving? This is, an important step. So feel free to reach out to me anytime. My cards are at the back of the room, too. And so once it's approved by the FAA, and then it's just a matter of filling out an FCC form, the 854. And this is my understanding, we have experts in the room on this, my understanding it's really just updating the ASR. I think it's an automated process. It can happen in about 24 hours, and then the FCC ASR database is up to date. And at that time, people can go to the tower or do it remotely, however their system's set up, and extinguish those side marker lights. And immediately increase your bird conservation and decrease your energy costs. It's an immediate fix. And when we talk about bird conservation, it's oftentimes a long game, where you're storing habitats, you're trying to get pesticides out of the environment. This is an instant fix. McCormick Place in Chicago, they could have turned off those lights and eliminated that problem that night. And we're talking to them about that, the community is, the bird conservation community is. So next slide, please. So again, towers taller than 350 feet, there's no tower climbing required for this fix. There's no additional cost or fees to extinguish the tower side marker lights. There's a financial savings due to decreased energy costs, decreased maintenance, decreased tower climbs, decreased construction cost, and there's a 70% reduction in bird fatalities. For those towers 150 to 350, it's a little bit more challenging in that LED systems are the best for that, and those have an additional cost up front, but then of course have money-saving options over the time. But currently, LEDs are the best option for reprogramming non-flashing to flash, and again, a 70% reduction in bird collisions. So next slide, please. So I'm putting this up here one more time, just to think, how do we finish this up? I haven't done the math, and the ASR would be a good place to get some of that information, and it is publicly available. I have not done the math yet, but I estimate that we're getting to be about half towers. Half of the old towers have extinguished their side marker lights. And I'm trying to think, how do we get to that next step? These lights are going to time out. I did the math. It's going to time out about the time I'm retiring. It'd be nice if I could see this, throughout, see it to fruition. But it would be really great to close the gap, and I hope we can, in this room, if you have any ideas on how do we reach some of those remaining tower owners that have not updated their tower lights. I just talked with a consulting group out of the southwestern part of the United States, and they're saying, we're going to put this as part of our business portfolio. We're going to offer to do this FAA work for them. They're going to save the money ultimately. It's a short cost, or a small cost for them up front, but they're going to ultimately reap the energy savings and the maintenance savings on this tower. And that might be something for others to consider as well. We'll do the legwork for you. You save the money ultimately. And we're all saving birds. I tease Richard Hickey. I don't know if anyone else knows Richard Hickey from Vertical Bridge. Yeah, and I tease him all the time, like, you save more birds than I do. I can sit here and talk about this. I personally cannot go turn off tower lights. I'd like to. That'd be fun sometime if Richard were to take me out there and say, your turn to flip the switch. But he's the one, and you guys are the ones reducing bird fatalities. I just get to talk about it and study it. And so it's a really neat opportunity, and I would encourage you guys to think about it and talk to me if you have any ideas or questions about how you might be able to incorporate this into some of your work to get more tower lights turned off and to close this gap. Because you guys already look at towers on the landscape now, but I bet you're going to start seeing those side markers a little bit more now when you drive around on the landscape and think those are the ones that are attracting in the birds. They flash, they're fine, but they don't flash, and they're attracting in birds. Okay, so feel free to talk to me about that now or later or whenever. I'll be around for lunch today too. Next slide. So yeah, that's what I'm talking about. How do we finish this change? And I'm not even sure where the barrier is, but I believe it's people just taking the time to get online and file that FAA paperwork. Because the FCC stuff's easy, but the FAA takes a little bit more time. Okay, next slide. All right, so now I want to move a little bit away from the tower lighting stuff and just talk about siting. I'll check the time. Doing okay? I want to just talk a little bit more about how do we site these facilities on the landscape to reduce impacts to migratory birds. This is straight from the Fish and Wildlife Service Migratory Bird Program guidance, which is available online. I didn't bring copies of that today, but I'm happy to send it to you if you'd like it. But so moving away from the towers on the landscape that were already built before 2015, and moving more towards new builds on the landscape. So it's important for us to reach out to the Fish and Wildlife Service field offices, and we just heard about that from Paul. He mentioned IPAC, and that's a nice addition to add to this first bullet. You might reach out to a Fish and Wildlife Service office, and they might say, we are so busy, please just go to IPAC and start there. That's a common response I remember when I worked with the FCC here. So reach out to the field office or work in IPAC or both. And it's important we understand at the Fish and Wildlife Service that it's not always possible just to co-locate at another tower. That's not the way the business model always works. But co-location does reduce the numbers of towers on the landscape and is better for birds that way. So co-location, and I say tower structures, but we know that it can be a lot of other structures too. That's helpful. Using existing tower farms or concentrating those towers in one area, we believe that helps reduce migratory bird collisions. And then selecting degraded areas already. So what comes to mind in that case is, for example, the eastern meadowlark, that we've lost 75% of their populations. They're probably not hitting a lot of towers, but they're suffering from habitat loss. And so building these structures in lands that's already degraded, such as an agricultural field versus a pristine grassland, that helps. And that's just one example. Avoiding wetlands or other known bird concentration areas. Oh, I think I'm getting ahead. I think we need to click the slides a couple times and highlight for your viewing pleasure. There you go. Thank you. So avoiding wetlands and other known bird concentration areas is important. And avoiding ridgelines and coastal areas. These are areas that concentrate migratory birds and during their migration, a migration that's already difficult. And so if we can avoid some of those areas, that's very helpful. Next slide, please, or next click. Avoiding vegetation removal and maintenance during bird nesting. So how am I going to know when a bird's nesting? I'm going to go to IPAC. That's a more commonly used tool. IPAC does include phenology or timing of when birds are in areas. And so if you get into IPAC for the area of where your tower is located, if you're planning to do some vegetation removal, you can look at when the birds are nesting and avoid that time period. Nest clearance surveys less than 5 days before clearing. That's also a good recommendation, but that's expensive and hard to do sometimes, and so it works, but we prefer that things be avoiding the nesting season completely if possible. And the next bullet, avoiding protected species, key habitats, prairie sage grouse, prairie/sage grouse leks. So again, that's all part of IPAC as well, and was mentioned by Paul, avoiding those areas that are sensitive to migratory birds. So what are prairie grouse or sage grouse and leks? Anybody know what the leks are? Those are pretty cool. And if you're bored tonight and you're trying to fall asleep, I would Google lekking of birds. It's pretty cool. So these prairie grouse, they're like chickens, a size, and they're a little fancier in color and stuff. And they actually do a dance in a lek. And the males all get together in the middle, and they tap their feet and they dance and they make really crazy noises. And the females watch from the outside and choose like where, who's the guy for them, right? And the more fit males are towards the middle, and the kind of stragglers are towards the outside. And it's quite a scene to see. And if you ever have an interest in birds, like Carrie does, I don't know, yeah, she's still there. I would encourage you at some point in life, go to like the prairie chickens in Wisconsin. They have blinds set up, so you sneak in before dawn, and you sit there and you wait for the chickens to wake up, and then you watch them dance, and it's so cool. It's very, very, they're right next to you, and you can like feel them, the noises that they're making in your chest. It's pretty neat. And I know this makes me think about, make sure I'm okay on time here, not talking too much, but it always reminds me of, I live in a college town, and I like run through the beer district, and I'm always looking at the guys, and they're like wearing sweatpants, and I'm like, this is not like a prairie chicken leg. Like the ladies are all dressed up, and the guys are wearing sweatpants, and I'm like, this is like wrong, This is not the way it should be. So anyway, prairie chicken leks and sage grouse leks are pretty neat, but they're sensitive. They're used to these open areas, like that's their niche, that's their home. And just like we can't imagine living under the ocean, it's not our home. They can't imagine doing their leks and breeding and doing their thing in a place with tall structures. So sometimes tall structures near chicken leks, prairie chicken or sage grouse, it can really disrupt them, and they'll move their leks or just abandon them. And so that's something to consider. Those are often regulated by state governments, and so you may need to talk with your state governments if you think you're near leks or have a concern about that. The state wildlife agencies. Okay, and then buffering eagle and hawk nests by half a mile to a mile is helpful. And this is, I'm going to just point out that bald eagles have been pretty adapted to people in our lifetimes. They've really adapted well and increased. Golden eagles is another story. So if people work in the West, well, we have eastern golden eagles too, but not as many. So the western golden eagles can be pretty sensitive compared to a bald eagle. Not all eagles are the same that way. And the second to last bullet there, prevent introduction of invasive species. Most places have programs to, and plans to reduce, most local entities have plans to reduce the introduction of invasive species. It could include washing equipment between moving it among sites, etc. And then one more click for the slides, please. Use motion sensor security lighting. Well, that's good, yeah. Motion sensor security lighting. This is not new to this industry. You guys are good at this. You often, or maybe always, almost always, are using motion sensor security lights. That's important. As we've been talking about bird attraction into non-flashing lights, it just like the McCormick Place in Chicago and steady burning lights on towers, they attract in migratory birds, even if they're just above a door. And so, but this industry has traditionally used motion sensor lights above their doors if they need any lighting at all. And that's great, and I'm really glad, and I encourage that to continue. Okay, next slide. So this, I always want to show you guys this video, and it doesn't work with the technology here. But again, when you're bored tonight, after you've looked at chicken legs, I encourage you to just type in win-win and Towers Birds. Towers Birds, win-win, whatever. And you're going to get this cool YouTube video that we put together at the Fish and Wildlife Service. And it's really, if people are in this room thinking, I'm going to try to work with more tower owners to extinguish lights, this is a great, almost 5-minute, but hardly 5-minute video to help convince them that this is something that's going to work. We have tower industry leaders in here. We have Richard Hickey from Vertical Bridge, I mentioned earlier. He speaks to how easy this is to extinguish side marker lights, how important it is, how good it's been for their business. And Jimmy Miller. Anybody know Jimmy Miller? He's with NATE, National Association of Tower Erectors. He was previously the president, but he just stepped down. And they do a great job at NATE suggesting this and as a proponent of extinguishing side marker lights as well. So they're in this video and really talk about the importance of doing this, the money that you'll save, and the birds that you'll save as well. So it's a cool little video. Okay, where are we? Is that slide? I think we had a thank you slide. There we go. That has my email address and my boss, Eric Kirshner, and some additional sites you can go to as well. So with that, I am ready for any questions you might have, or we go to the Garnett.
Thank you, Joelle, and Paul as well. Actually, I have one bird-specific question. This is off the fly, so I'm not,
Okay.
I'm just assuming Joelle is going to be able to answer
We'll
this.
see.
So we had someone come in with a question about that they're seeing more peregrine falcons take over osprey nests in the Northeast.
Really?
And, I guess.
That's cool. I guess from a bird perspective, that's interesting, yeah.
And I guess apparently they're non-migratory. And do you have any thoughts about how, the tower industry could address those issues?
Yeah, so did you say northwest or northeast?
Northeast.
Northeast,
It looks like
okay.
it's northeast.
That's interesting. So, as I think through this, I'll just say peregrine falcons, they suffered significant declines in the era of DDT as well. And so their populations are recovering. They nest in urban areas oftentimes. And as a falcon, and Carrie will find this interesting, they don't build nests. They use a little cliff, and they don't bring in sticks. They have to depend on either a cliff or a water tower or a bridge or something that they can just go in there and they make a little scrape. It's not a very comfortable thing for a peregrine falcon chick, apparently, but it's just a hard surface, and they will nest in that place, in that situation. So the fact that they're coming in and using the nests of other species doesn't surprise me completely, but I hadn't heard it. So they're not building those nests. They're not carrying sticks like you'll see an eagle or an osprey doing. They're just coming in and using it. It's kind of squatting, I guess, in a way. But so that is interesting to me. So the question is, what can they do about it? I'm going to just say something that's not terribly popular because I think all of us know that it's not always successful. But nest exclusion devices, I think, would be the best option in that case. And then peregrines, they are protected by the Migratory Bird Treaty Act. They are not protected by the Bald and Golden Eagle Protection Act, but they do have MBTA protection, and that does we have some guidance that is probably coming out soon, we hope, and that will allows a greater flexibility with removing nests that are used by species protected under MBTA, but not the Bald and Golden Eagle Protection Act. So there may be some options for nest removal at some point if it's not used by the eagles anymore, but that would be something you'd want to work with the state on. So I would suggest, in summary, working with the state to see what you can do with that structure.
Great, thank you,
But
Joelle.
not during the nesting season. When there are eggs and birds using it, you can't do anything. But when they're not in use, you can possibly remove it by working with the state.
Thank you.
Mm-hmm.
Excellent. Okay, I am actually for a few minutes going to hand it over to my colleague Shannon Lipp here. During the course of the past two presentations, we did get several questions about enforcement-related issues. So I'm going to hand it over to Shannon here to take some of those.
Hi. Okay, so we got a question asking whether the FCC publishes the names of entities with complaints filed against them or those that are under investigation. We don't keep a public database of ongoing investigations or potentially non-compliant facilities, but all enforcement actions are available on our public-facing website. It permits filtering by year and enforcement type, and you can find that at fcc.gov/enforcement/orders. Then we got a question asking whether all environmental rules need to be completed prior to Enforcement Bureau conclusion. What needs to happen with the tower at issue? Does it need to be decommissioned or something else? So the Enforcement Bureau will review potential violations and will pursue enforcement action when it's warranted. It's very important that entities take care to comply with FCC rules, and any entity, for example, an entity must come into full compliance before the Commission will consider negotiating any kind of settlement. And any enforcement-related questions that are site-specific, we encourage interested parties to reach out to the Enforcement Bureau at eb-sed-response@fcc.gov. And then the last question was asking whether if somebody knows that a facility isn't in compliance, will they be responsible if they don't tell the Enforcement Bureau about it? So it's the applicant's responsibility to ensure that tower construction complies with all Commission rules. And we routinely review complaints from third parties, and we welcome information from all interested parties. So please let us know if there's some, if you see something, say something. Yeah, that's it.
Excuse me. Thank you, Shannon. That's really helpful. So one question we had, and I'm looking at Joelle because actually she helped prepare the FCC for the response to this. In a sense, it involves site testing involving ground disturbance and what you can do prior to construction of the tower. And so we have very specific guidance on our website about this. It's the tower antenna siting page, and there's a direct link and a fact sheet to this. But basically, the FCC's policy regarding which project activities may take place prior to a NEPA decision. So applicants may perform limited preliminary site evaluation activities prior to a NEPA position. What activities are considered preliminary site evaluation activities? Wetland delineation, archaeological investigation, endangered species assessments, geotechnical exploration. There are very specific guidance on these issues on our website, so I recommend everyone go there. There's a specific link on our tower antenna siting webpage, and you'll see that webpage throughout the various slides today. So I recommend everyone take a very close look at that. And I note that several years ago, Joelle worked on this particular fact sheet. So
I was
No,
like,
no,
oh,
I
I
wouldn't
don't know
do
if I
that
remember
to
the
John.
details. I'll look at the website.
Yeah. So another question that we received, which hits upon Paul's presentation, was, do NEPA and NHPA requirements apply to those services that are licensed by rule? I think this issue is coming up often in regards to particular spectrum band, the 3.5 gigahertz band. Part of it is licensed by rule, if you're familiar with this. And the answer is yes. Structures that are intended for use for spectrum bands that are licensed by rule are subject to NEPA and NHPA. Applicants that deploy using spectrum that is licensed by rule are subject, again, to the NHPA NEPA Commission rules. If a facility is intended to support unlicensed use only, it is only going to be used for unlicensed services, then the NHPA NEPA rules do not apply. One other question that we received regards our biologists and who the industry should contact at the FCC for biological questions. The FCC does not currently have a biologist on staff. We have posted for the position, and we're hoping to fill it very soon. In the meantime, if applicants or the public generally have questions, that they would normally work with our biologist, our infrastructure team staff are available to help facilitate the process, and it's many of the people that you're seeing today, including myself, all of my colleagues here. Throughout the day, we're all going to be available to answer questions. So thank you. And so with that, I think we're now poised for a break, and we're going to reconvene at, I believe right now, we're going to reconvene at 11:45 to talk about antenna structure registration requirements. That's very exciting, I know. So we'll see you in just a few minutes, everyone. Thank you. Okay. Okay, everyone, it's time to reconvene. It's nice. I know it's nice to see everyone in person and chat and catch up and so forth, but we do have quite a bit to cover today, so we have to stay on schedule. So thanks again, everyone, for coming back. Our next presentation will be on an overview of the antenna structure registration requirements, and will be presented by Michael Smith, an analyst of the Competition and Infrastructure Policy Division. Mike has a lot to cover. And thank you, Mike. I'm going to hand it over to you.
You're welcome. Sounds like people can hear me, right? Yep. Okay, doke. Well, welcome back, and good morning, everyone. We're going to have a little chit-chat about ASR. I know you're all excited. My name is Michael Smith, and I work in CIPD. Some of you may have talked to me over the years. Let's see where we're going slide-wise. There I am. See, I am a person. That's nice. Okie doke. Intro. Next slide, please. Oh. All right. Well, we'll do this. We'll do this a little differently. Okay. We're going to talk about, generally speaking, ASR overall, but we're talking about the registration itself, some FAA requirements, and some environmental requirements. Next slide. Okay, what is ASR? As you all probably know, it's our online system that stores information about the tower. The things that your usual suspect, right? Your tower owner, contact information. And by the way, make sure that the contact information and the tower owner, all that stuff is updated, because it's really a pain if it's not. And if there's a problem with lighting on the tower, that's where we go to know who to call to fix the lighting on the tower, and pilot safety's involved. So we don't want to mess with that. Other things, structure type, location, height, lighting. You'll be able to find public notice dates in there, well, at least the national notice date. Waiver requests, decision documents, and other attachments. Now, to get the final registration, you do have to do the FAA study number. You have to get an FAA study and and enter in eventually the study number and the issue date. But you don't have to do that until the Part 2. So when you first do your original application, you don't have to have the FAA study. You can do it on parallel courses. But by the end, in order to get the registration, you do have to have the FAA study number. Let's see. And as you can see in red, construction cannot begin until you get the ASR registration. And I'll mention this later, but some people think that once they get a FONSI, or a finding of no significant impact, that they could start building. Nuh-uh. It's registration. You have to get the registration first, but we'll talk about that in a bit. Next slide. Okay, FAA. Now, the tower has to be registered in ASR if it's over 200 feet or a physical obstruction with the FAA. And it's a physical obstruction with the FAA if it fails the slope test. And there's a couple tools out there that you can tell whether it fails the slope test or not. There's FCC's TOW Air or the FAA's notice criteria tool. And, I would use those. And again, if ASR is required, you must provide the valid FAA study number. Okay, next slide. Okay. Environmental notification requirements. In 2011, the Commission adopted the rules for the notification process. And unless an exception or a waiver is granted, all towers have to do the notification process. And sometimes they have to do it more than once. Sometimes it's unavoidable, and sometimes it's avoidable. And you want to avoid the ones that are avoidable. Next slide. Okay. This is sort of an overview about ASR in general. And I'll go over this, but I'll try to give you a general overview so when you hear something, you can put the posts in about where along the timeline things happen. So generally speaking, you'll do your ASR application and you'll put in whatever information you can. Things like all your where it is, how high it is, if there's going to be lighting, all the general stuff. But you're doing that in order to get the ASR application number. You need the ASR application number because you're going to put that in your local notice. And your local notice has to be before, well, it's on or before, but just remember it's before. That'll save you some suffering. Before the national notice. That's important. Local notice before national notice. And the 30-day comment period is initiated by the national notice date that you choose. Now, you can choose a national notice date in the future. So today is November 2nd. Okay, let's say I do my application today, but I don't have my local notice done, obviously, because I just now got it. I just now got the ASR application number. So when you're putting it in, you can pick a national notice date, say 2 weeks ahead or a month ahead, to give you time to do the local notice. And that way, you always make sure that the local notice is before the national notice. Secondly, the national notice starts the comment period. So people can comment on the ASR application. They can say this one says that there's no EA going to be proffered, but we think there should. Or the EA is here, but we think it's insufficient. So people can comment then. So once all of these things are done, the comment period passes. If there's an EA, a FONSI is granted. If there's an MOA, all of that is handled. When all of the steps are done, then you can go into that bottom bit, which is the Part 2 certification. That's when you need your FAA study number. And we'll discuss Part 2 as well a little bit later. Next slide. Okay. Now, everybody has to do environmental notifications, but there are a few exceptions. There are 7 of them. Some are if the application is for notification only, or if there's a reduction in tower size, change in lighting, change does not alter the physical structure, lighting, or location, the federal agency exception, and the temporary tower. And we'll discuss temporary tower in a bit. Now, there's also one for an emergency waiver, but that is very, very rare. Think hurricane. We rarely grant them because there's rarely an emergency that would require such a grant. Next slide. Okay, replacement towers. Now, replacement towers qualify you for an exception to the local and national notice if it's at the same geographic location, doesn't require an EA, does not use a less preferred lighting style, does not involve a substantial increase in height, which is either 10% of the height of the tower or 20 feet, whichever is greater, and does not involve construction more than 30 feet beyond the existing antenna structure property. Now, part of the substantial increase in size, you can see in the bottom note, also includes if you're adding new equipment cabinets, so it has to do with the width of the tower as well, not just the height. And for those of you playing with our FCC ASR home game, I believe that site is, it's App B, Part 1 App B. We'll have the 1 through 4s for the substantial increase in height. Next slide. Okay, temporary towers. There are 5 things you need, well, really 4, because 2 are one and the part and parcel of the other. It can only be in place for 60 days, and you have to talk with the FAA and get no hazard determination where it says no lighting is required. So that's either 2 or 1, depending if you lump it in. Be less than 200 feet height and involve minimal ground disturbance. Now, think about temporary towers. And for example, just FYI, these are things that you'd put in for like an air show or a football game or something where they need a little bit more capacity. They're only allowed for 60 days. Once they're 60 days over, you have to take them down for 30 days. Then you can refile for another 60 days. Next slide. Okay. Back to the original ASR application. These are the things that we've discussed earlier that you need at the start of the ASR application process. And it's the things that we've discussed, you know, address, phone number, the contact information, height, type of structure, what marking or lighting you're going to do, and the rest of this. But you'll notice that the FAA study is not listed among them. Again, that can be done concurrently, but it needs to be done before you do the Part 2 certification. I'll take a second here to remind everybody that you have to make sure that the stuff that you're saying in ASR, the stuff that you're telling people in the notice, and what you're telling to the FAA, all the same. If not, you're going to have to redo it. So if you tell people in the local notice that this tower is going to be unlit and the FAA says, it has to be lit, you got to do local notice again. If there's a change in height, if you're telling the FAA one thing and you're telling the people in the local notice another, that's a problem. So make sure those three things are all the same. It'll save you some serious suffering in the end. Okay. Next slide, please. The FAA no hazard determination. As I may have mentioned, you don't need it at the start. It's got to match what you tell everybody else. Got to be match the local notice, and it's got to match what's in ASR. If not, you got to redo some stuff. And as noted on the bottom, you can't get an ASR registration without a valid FAA study number. Next slide. Okay, local public notice. Again, you don't need your local public notice up front per se. Well, you can't really do it because you need the ASR application number. So probably the best way to run this, do your application, get your ASR application number, pick a national notice date that's out a couple weeks or a month, and then get the local notice published. But be sure when the paper says we're going to publish it on, let's say, November 15th, and you tell ASR in the national notice that it's going to come out on the 5th, that the national notice date would be the 15th or the 16th. If they don't publish it when they say they're going to, and then publish it, say, on the 20th, you got to do it over again. So be careful when you pick the national notice date to make sure that you can get the local notice date published before then. Okay, location and content. Just publish it in the local newspaper. That's the standard. But you can also publish it, you know, if there's a governmental website that's a standard way people in that locality get the information, that's probably okay too, because the goal of notice, as you may have guessed, is notice. So if people understand that the tower's going up, you know, we don't necessarily care which way it is, but local newspaper is usually the standard, and almost all places have a local newspaper. But make sure it's the local newspaper, not one that's kind of close, because that might not be considered local notice for these purposes, because people may not look into it sufficiently to know that a tower's going up. And so the things that you're going to want to put in there, again, the 854, so the ASR application number, location, structure type, height, lighting. Make sure it matches what you're telling FAA and ASR. You also need to include a statement that interested persons may access and review the application at here. So people want to look the application up, they can, and they know how to do that. And also a statement telling them where they can go if they have a comment, and a contact for them to contact. Next slide. Okay, combining local public notices. You also have to do notice for the Section 106 process, but you don't have to do them separately if you don't want to. You can combine them, but make sure that all the things that go into both of them are all in a pile. So the things that you want to do in the local public notices for SN 106 are those four indicated. Street address, description of the facility, type and height, instructions on how to submit comments, as you saw before, and name and phone number of the contact person. Now, there's a little caveat, a little warning about publishing notice on websites, especially pay websites. People don't have the access to that, and then you get in trouble with, does this qualify as notice for this purpose? If only a few people can either access this website, know about it, have to pay for it, stuff like that. Okay, next slide. Okay, national public notice. We've covered a bit of this. Okay, it's required, of course. On the date applicant requests, the commission will post the application and it will remain posted for 30 days. Okay, the date the applicant requests. Remember, the day that you put in there, that starts the 30-day comment period. And we'll discuss that here in a bit. But you can choose a date in the future. Most often it's done to accommodate the time for the local notice, and that's probably the best way to do it. And if you make a mistake, you can go back in and rechange the national notice date, but again, that resets the comment period when that's done. Also, if, say, for example, if something substantive changes about your application, let's say you didn't know that you were going to do an EA, but it turns out that you have to do it. So in the original application, you say no EA, but now you're changing it. That's a substantive change, and so you'll need to change the national notice date. So people have the full 30 days to comment on the EA. And again, there's some warnings. National notice date must not precede local notice. This is what starts the pleading cycle. And you can change the national notice date if you need to. But notice the bottom one. If national notice date is set originally and somebody comments, let's say there's 2 or 3 people that comment on that and say, we think you should have done an EA. Okay, so then you do an EA. When you submit the EA, that will reset the national notice date. So people will again have a full 30 days to comment on the new information, the new substantive information, essentially the EA. So we give people the full amount of time to comment for substantive changes. Next slide. Okay, national notice, where to find it. That's a website. I don't need to beat you over the head with that. Next slide. Okay. Request for further environmental review, the pleading cycle. Once the national notice date is set, starts the 30 days. And anytime within the 30 days, people can submit a comment. It's usually either there's been no EA has been submitted, but there should have been, or an EA has been submitted and we think it's insufficient. So the timelines, you have the first 30 days for people to comment, and then you have the applicant has 10 days to submit an opposition. And if the 10th day is on a weekend or a holiday, it's bumped to the next day. After that partition, the commenter has 5 days to reply to the opposition, and the 5 days are only business days. Weekends, holidays don't count in the 5. Next slide. Okay, these requests, somebody comments. Typically, as I said before, it's either there's no EA and we think there should be one, or the EA was submitted but we think it's insufficient. Now, for those that may be listening to this that may file comments in the future, You need to be specific with what the issue is. Be specific. General statements usually won't be effective. The comments must be submitted electronically, but you can mail them in if you request a waiver. And again, you must set forth detailed reasons for that. Next slide. Okay. Part 2 certification. This can only happen when all other things are done. So if there was an MOA, that's all handled. If there was an EA, the commission will had to have granted a finding of no significant impact, or a FONSI. And all requests for further review, any comments, that whole process must be all completed before you can get to the Part 2. Because you're attesting that there's no significant environmental effects. So you have to have all that stuff done so you know that you can attest to that. Now, just as a caveat on the FONSI, it's not permission to start building. The registration is permission to start building, not the FONSI. So you have to wait till the process is completely done and you get your registration before you can start construction. Also, here is where your FAA study is required. You have to have your FAA study by this time, and it's part of the Part 2 certification. Next slide. Okay. Sometimes you have to do environmental notification more than once. The first bullet, defects, right? The local notice, there was some issue. Tower height was wrong. The tower lighting bit was wrong. The location was wrong. There was some defect. And sometimes the additional notice is in applications, and sometimes it's in registrations. And that's what we're coming to next. Next slide. Okay, amendments to pending applications. Any change in the structure type or coordinates, you need a new local notice. Any increase in tower height, new local notice. Any change in the lighting style to a less preferred, need new local notice. Because your other one told them something different, so there wasn't really notice of what's actually happening. Things that don't require new notification are reductions in height, because people usually aren't going to complain, well, I thought it was going to be a 250-foot tower and it's only 200 feet. Proposed lighting is removed or changed to an equally or more preferred, or purely administrative changes. You're changing ownership information or some such. Next slide. Okay, modifications of existing registrations. This is whether it's a difference between a major mod and a minor mod. Now, again, with all this stuff, you can always check with us to see before you do something, and we'll give it a good think through. Major mods are substantial increases in height. That's the 10% or 20 feet, whichever is greater. If it's bigger than that, it's a substantial increase in height. You got to do new local notice and national notice. If you're submitting an environmental assessment, or if you're changing lighting styles, those require new notice. The minor mods don't, just typically administrative changes of different flavors. You're updating the FAA study number, you're correcting coordinates, lowering the overall height, or changing the lighting to a more preferred lighting style. Next slide. Okay, this is just a minor bit. If you're a licensee and you're submitting Form 601, and it also has to be registered in ASR, if you've got the ASR registration number, great, put that in. If you don't, the ASR application number will suffice if those 3 bullet points. You've got the no hazard determination, you've done the local notice, and the national notice that's been put up to the website. So just a minor detail. But in closing, I just want to reiterate, be careful and make sure that the things match, because it can cause a lot of grief. For example, if you go through the entire pleading process, right? Somebody has comments, you go through that entire process, okay, we've got that handled, let's do the Part 2 certification. Oops, local notice is messed up somehow. Now you have to do local notice again. And because you have to do local notice again, then you have to do national notice again, because the local notice has to be before national notice. And when you do national notice again, people have 30 more days to comment. So you might have to go through the comment process all over. So do yourselves a favor, make sure the stuff matches and is correct between the FAA study, ASR, and your local notice. And that's pretty much it. Garnet?
Thanks, Mike. We had a couple questions. I have to say we're probably going to have to. I'll try and answer one, which I think comes up often. Many applicants ask about, voluntary submission in the ASR system and whether or not the same rules apply. And Mike nods yes. The same rules apply if you're voluntarily putting it in the ASR system, if you need to submit an EA and, you want to make sure that do your adequate environmental notice on the EA, you need to put it in the ASR system, and all those rules apply.
Yep.
So another question, Mike, that we got was about temporary towers and if you need to continue using the tower after the set period of time, which I think is 60 days. Is that right?
Yeah, 60 days. Do you
Yeah.
have to continue?
No, if you have a need for it.
No, you can't. It's 60 days, you take it down, you wait 30 days, and then you can put it back up.
Okay, thank you.
Yeah.
He's very clear on that one. Thank you again, Mike. Okay, we're now moving on to our next set of presentations, and these will be virtual. We'll do an introduction to infrastructure used for 5G technology, and second, how to approach the Section 106 compliance. Saurabh Chabra, a senior electronics engineer from the Competition and Infrastructure Policy Division, will present, as well as Robert Krensky, an attorney advisor from the Competition and Infrastructure Policy Division, will present on Section 106 compliance. And so first, I'll hand it over to Saurabh. Thank you. Saurabh, I can't hear you.
Can you hear me now?
I can. Thank you.
Perfect. All right. Thank you, Garnet. As Garnet mentioned, my name is Saurabh Chabra. I'm a senior electronics engineer within CIPD, which is in WTB at the FCC. So my colleague and I will today talk about small wireless facilities. We'll give a introduction to infrastructure used for 5G technology, and then Robert will talk about how to approach Section 106 compliance. And we know our presentations is keeping you from lunch, so we will try to speed things up so that you have enough time for lunch. All right, let's look at the agenda slide. So I will be talking about an introduction to infrastructure used for 5G technology. We'll go over what a 5G cell network looks like at a high level. What is 5G? Types of infrastructure used for 5G. We'll look at a few examples of macro cells, and then talk about, is there a need for small wireless facilities? And then we'll look at examples of those small wireless facilities. And then we'll wrap it up with number of macro cells and small cells in use in the US today. We will then move on to Robert's presentation on streamlined Section 106 review of small wireless facilities. Next slide, please. Next one. All right, so here's a high-level overview of 5G cellular networks. As you can see on the left-hand side, there's a cell phone communicating with a base station, which connects to a core network. In simple terms, that's how your cell phone works. Networks of today use both 4G and 5G technology, so there can be a mix of 5G base stations and 4G base stations, and there can be two cores, the 4G core or the 5G core as well. Next slide, please. So we've talked about 5G and 4G, but what is 5G and how does that compare to previous generations? So previous generations, as you can see, started with 1G, which was really all about mobile telephony. And then almost a decade later, there was an introduction to 2G, which was mobile telephony for everyone. Then 3G came along another decade later, which built the foundation of mobile broadband. 4G enhanced that mobile broadband. And now 5G is really about embracing a network society. And we'll see how in the next few slides. Next slide, please. So the use cases for 5G as defined by ITU are enhanced mobile broadband, or EMBB, ultra reliable and low latency communications, and massive machine type communications. As you can see, these are different use cases. When we're talking enhanced mobile broadband, peak download data rate goal is to be near 20 gigabits per second. When you're talking about ultra reliable and low latency communications, we're talking latencies of less than 1 millisecond. And when you're talking about massive machine type communications, which generally are referred to as IoT, the connection density there is more than 1 million per square kilometer. Next slide, please. So how does this differ from 4G? As you can see, 4G was the download peak speeds there were about 1 gigabit per second. This is in the latest versions of 4G, advanced versions of 4G. And 5G will accomplish 20 gigabits per second. There's a lot more bandwidth available with 5G. As you can see, thousands of megahertz of bandwidth available. Download speeds in the real world will be near 100, even more, 100 megabits per second with 5G. And latency, again, with 4G, advanced versions of 4G LTE, we're close to about 10 millisecond. And now with 5G, we're trying to get as close as we can to 1 millisecond and even lower. Next slide, please. So what types of infrastructure are used for 5G technologies? Like previous technology, 4G LTE, there are two types of technologies being used, infrastructures are being used, macro cells and small wireless facilities. Macro cells in general cover large geographic areas from 8 to 30 kilometers in radius, and they have relatively high capacity. They have antennas that are typically mounted on tall towers or rooftops of tall buildings, and they're working at higher power levels. Small wireless facilities, on the other hand, can be fraction of the size of these traditional cell towers, and they can be installed on utility poles, buildings, and other existing structure. But they're trying to cover locations within a few 100 meters to up to 2 kilometers in radius. Essentially, what they do is move a radio closer to the user so you can provide additional capacity in areas that have high demands for both wireless voice and data services. Essentially, it improves the quality of service and the user experience. Next slide, please. Here's a quick look at what a macro tower looks like compared to a small wireless facility. On the left-hand side, you see a guide tower or a lattice tower, and that has 3 different sections, maybe even 4 sections of antennas to cover a large area. Now, those might be by different providers. And on the right-hand side is a picture of a small cell on a lamppost next to a building. Next slide, please. And the next one. So here's an example of a macro cell tower. This is a lattice cellular tower. You see antennas all the way at the top. These are tall towers. They can range anywhere from a few hundred feet to, more like 500 feet even. Next slide, please. Here's an example of a monopole macro cell tower. Again, a few sections, a few rows of antennas for different providers. Next slide, please. Here's an example of a stealth flagpole monopole. So the antenna and the equipment are embedded in the pole, but it looks like a flagpole. Next slide, please. Here's a stealth monopole that looks like a tree, which is great when it's not winter or fall, because those are the only months that might stand out. Otherwise, it's stealth well. Next slide, please. Here's an example of a building-mounted camouflage cellular antenna. So these are antennas that are on the sides of buildings. You'll have these antennas on this side, and perhaps on the other side of the building, there would be more towers hanging off the building as well. Next slide, please. So is there truly a need for these small wireless facilities? As you notice, there's a lot of increase in demand for mobile traffic, higher data rates in today's 4G and 5G networks. And there's one of 3 ways we can achieve that. Well, you can have more spectrum available. You can use that spectrum more efficiently, or you can densify the network. And densify really means adding more cell sites, whether they're macro cell sites or small cell or small wireless facilities. And densification technologies like DAS and small cells really help out with densifying the networks, because macro cells cover large distances, and adding capacity and coverage to localized areas are done through DAS, outdoor DAS, or small cells. Next slide, please. So what is a small cell? These are definitions. A few of these definitions are from Small Cell Forum, and they define a small cell as a low-cost radio access point with low RF power output, footprint, and range. They can be deployed indoors or outdoors. They can be deployed in licensed, shared, or unlicensed bands. Essentially, what they do is they provide coverage in smaller areas by using small form factor, small antenna heights, and small power. You've heard of femtocells, picocells, and microcells, and even metrocells. These are all types of small cells, from the smallest being femtocell and the largest being microcell or a metrocell. Next slide, please. How does that compare to a DAS system? So DAS system is a distributed antenna system, which really distributes RF signals from a central point, as you see in that picture, a central hub or a head-end unit. It distributes signals from there to nodes attached at each of those light poles. So there would be DAS nodes at those poles and antennas installed at those poles. Now they work well inside large buildings. They work well in campus settings, stadiums, even outdoor venues, city blocks, things of that nature. They can support a variety of frequency bands and technologies as well. Next slide, please. Here's an example of an outdoor DAS and a small cell to show you how similar looking these can be. These can be installed on a pole. They might have similar things attached to them. For instance, a power meter, a demarc box, fiber connection, antenna all the way at the top. In case of a DAS, there might be a power amplifier, as you can see on the left-hand side. And on the right side, you see a small cell. And some small cells don't even need the antenna all the way at the top. They can have an integrated antenna, one or two antennas, integrated into the small cell radio unit. Next slide, please. And here are some examples of small wireless facilities. This is an equipment enclosure that houses remote radio heads for small cells, and they would include space for power supply, for a disconnect switch, for battery compartment. Next slide, please. Here's an example of a rooftop platform-mounted small cell deployment. So this would be hidden from view, but the antennas would be either hanging off the building or somewhere in the vision there. And as you can see, again, the same type of equipment is used here. Next slide, please. Here's an example of a small wireless facility in historic Central Park, New York. It's on a light pole. You see towards the middle, there's some equipment there. That's a small wireless facility equipment, and then an antenna all the way at the top. Next slide, please. Here's an example of a small facility in Pittsburgh, historic Pittsburgh, Pennsylvania. There's a canister antenna all the way at the top, and the rest of the equipment is housed at the bottom of the pole, hidden from public view. Next slide, please. And here are yet other examples of small cells on utility poles. Next slide, please. One other example of a small cell on a lamppost. You see two antennas looking in different directions, some equipment just below that antenna, and it's on a light pole. Next slide, please. Here's an example of a CELT small cell pole. Essentially, equipment is hidden inside the pole structure at the bottom of the pole, and all the wires, cabling hidden inside the pole, leading up to the canister antenna all the way at the top. There might be more than one antennas there, as you can see. Next slide, please. Now, there are a lot of macro cells and small cells in the US, and these are statistics provided by WIA. At the end of year 2022, there were about 142,000 cell towers deployed, and there were about 209,000 macro cell sites. The difference between cell towers and macro cells is macro cells can include deployments on buildings, on other tall structures like water tanks and all that too. And then there were close to 452,000 outdoor small cell nodes that were deployed. And there were a lot more indoor small cell nodes deployed, close to about 747,000. The point here is that there are a lot of small cells in use today, and it's only going to grow in the future. Next slide, please. With that, I'm going to turn it over to my colleague, Robert Krinsky. He will talk about streamlined NEPA and Section 106 review of small wireless facilities.
Thank you, Sarb. Thank you, Sarb. Good morning, everyone. Today, I'm going to cover how both the environmental and historic preservation review processes for small wireless facilities have been streamlined to account for the fact that the lower visibility of these facilities compared to macro cells make it less likely to cause adverse effects on either historic properties or the environment. Slide 1, please. First, it is important to know that many small wireless facilities are deployed as co-locations. These are on existing poles, towers, buildings, and other structures. The actions taken to streamline the review of small wireless facilities were an extension of previous steps to streamline the co-location review process. Next slide, please. For NEPA review, the co-location of small wireless facilities generally qualify for the Commission's categorical exclusions, which were adopted in 1986. In general, co-locations are categorically excluded from detailed NEPA review. There are 2 exceptions. First, the categorical exclusion is not applicable to deployments that would cause human exposure to radio frequency emissions in excess of the Commission's established guidelines. Second, the exemption is not applicable to deployments that may affect historic properties or that are listed in or eligible for listing in the National Register. Next slide, please. In 2001, the nationwide programmatic agreement for co-locations was adopted to address situations that may affect historic properties. Co-location NPA, or co-location agreement, as it is commonly called, was jointly agreed upon by the National Conference of State Historic Preservation Officers, the Advisory Council on Historic Preservation, and the FCC or Commission. In many circumstances, the co-location agreement streamlines the Section 106 process. The 2001 co-location agreement excluded from review most co-locations on towers, buildings, and other non-tower structures, but made 2 notable exceptions. First, the 2001 version of the co-location agreement did not exclude from review co-locations on or near any historic building or structure. Second, the 2001 version of the co-location agreement did not exclude co-locations on any building or structure that was over 45 years old. After the 2001 version of the co-location agreement, the development of small wireless facilities offered the opportunity, under certain circumstances, to place antennas on or near buildings and structures more than 45 years old. Next slide, please. In 2016, Nick Schippo, the Advisory Council, and the Commission amended the co-location agreement to provide additional exclusions for small wireless facilities. The amendment expands exclusions in 2 categories. First, under certain conditions, small wireless facility co-locations are excluded on buildings and structures regardless of age, as long as the buildings or structures are not historic properties or in or near historic districts. Second, it adopted a limited exclusion for small wireless facility co-locations on buildings and structures that are historic properties or in or near historic districts. Next slide, please. With regard to buildings or structures that are more than 45 years old, co-locations of small wireless facilities are excluded from Section 106 review unless either one of the following 3 situations applies. First, the building or structure is located inside an historic district or is visible within 250 feet of an historic district, or second, the building or structure is a designated National Historic Landmark or listed in or eligible for listing in the National Register, or third, the small wireless facility causes new ground disturbance. Next slide, please. Small wireless facilities on buildings or structures that are more than 45 years old must meet specific size limitations. First, each individual antenna may be no more than 3 cubic feet in volume. If there is more than 1 antenna, the limit is no more than 6 cubic feet in volume when measured cumulatively. Second, the equipment associated with the antennas cannot exceed 21 cubic feet if the equipment is on a pole and cannot exceed 28 cubic feet if the equipment is on a non-pole structure. Third, if the location can support at least 3 providers on a pole, the associated equipment cannot exceed 28 cubic feet. For a non-pole structure, the limit is 35 cubic feet if there are at least 3 providers. Next slide, please. 2016 amendment to the co-location agreement has 3 exclusions for small wireless facilities. First, there's the general exclusion for small wireless facilities on or inside historic properties or inside or near historic districts. Second, there's an exclusion for small wireless facilities installed on utility poles and electric transmission towers that are historic properties or inside or near an historic district. Third, there's a streamlined process for small wireless facilities placed on lighting structures in historic districts. Next slide, please. Let's consider each of these exclusions in depth. First, the general exclusion for co-location of small wireless facilities on an historic property or in or near an historic district only applies if the following 6 conditions are met. First, the building cannot be a National Historic Landmark. Second, there must not be any pre-existing antennas on the building or structure. Third, the antenna must be disguised or stealth to complement the building or structure. Fourth, the antenna on the building or structure cannot be larger than 3 cubic feet. Fifth, the antenna's associated equipment may not be visible from public streets or public spaces from a ground level vantage point anywhere within 250-foot radius of an historic district. And sixth, the deployment may not cause new ground disturbance. Next slide, please. The second category, which concerns utility structures, excludes the co-location of small wireless facilities on utility poles or electric transmission towers located in or near an historic district, if the following 4 conditions are met. First, the structure cannot be a National Historic Landmark. Second, the antenna on the structure cannot exceed 3 cubic feet. If there is more than 1 antenna, the cumulative volume of all antennas cannot exceed 6 cubic feet. Third, the antenna's associated equipment cannot cumulatively exceed 21 cubic feet. And fourth, there cannot be new ground disturbance. Next slide, please. The third category excludes co-locations of small wireless facilities on structures primarily used for public lighting that are located in or near historic districts if the following 4 conditions are met. First, the structure cannot be a National Historic Landmark or listed in or eligible for listing in the National Register of Historic Places. Second, the antenna cannot measure more than 3 cubic feet. If there is more than 1 antenna, on the lighting structure, the cumulative volume of all antennas cannot exceed 6 cubic feet. Third, the antenna's associated equipment attached to the lighting structure cannot cumulatively exceed 21 cubic feet. Fourth, there cannot be new ground disturbance. Next slide, please. If a small wireless facility to be co-located on a lighting structure meets these 4 conditions, the following procedural steps must be followed. First, the applicant must determine that the lighting structure is not a contributing or compatible element within the historic district. Second, the applicant must request in writing that the SHPO concur with the applicant's determination that the lighting structure is not a contributing or compatible element within the historic district. After the second step, the SHPO has 30 days to respond. If the SHPO either informs the applicant that the structure is not a contributing or compatible element, or the SHPO does not respond to the applicant within the 30-day period, the applicant has no further Section 106 review obligations. Next slide, please. The utility pole replacement exclusion from the Section 106 review process is not in the co-location agreement. This particular exclusion was adopted by the Commission in the 2017 pole replacement report and order. It is an exclusion that may be available when a small wireless facility is placed on the new replacement utility pole. It is important to emphasize that the utility pole replacement exclusion applies only if the original pole being replaced was not constructed for the sole or primary purpose of supporting an antenna for FCC licensed services. The exclusion was adopted in part to help expedite the deployment of small wireless facilities on utility poles. Next slide, please. Utility pole replacement will be excluded from Section 106 review if the original pole and the replacement pole meet certain criteria. First, let's consider the original pole. The original pole must meet 3 criteria. First, the original pole must have been able to hold utility, communications, or related transmission lines. Second, the original pole must not have been built and installed for the sole or primary purpose of supporting antennas that operate pursuant to an FCC-issued spectrum license. And third, the pole itself cannot be an historic property. Next slide, please. Regarding the characteristics of the new replacement pole, 4 criteria must be met to qualify for the pole replacement exclusion. First, the location of the replacement pole cannot be more than 10 feet away from the site of the original pole. Second, the replacement pole cannot result in new ground disturbance, either laterally or in depth, outside the previously disturbed area of the original pole. Third, the height of the replacement pole cannot exceed the height of the original pole by more than 5 feet or 10% of the height of the original pole, whichever is greater. And fourth, the replacement pole must be consistent with the appearance and quality of the original pole. Next slide, please. One more very important point to make about the replacement pole exclusion. The exclusion applies only to the replacement pole. It does not apply to the antenna. In the 2017 Pole Replacement Report and Order, footnote 25 provides that antennae are separately deployed. Antenna on replacement poles remain subject to the Commission's historic preservation rules concerning antenna deployments, including the exemptions in the co-location agreement. This means applicants seeking to locate small wireless facilities on replacement poles excluded from review under the 2017 Pole Replacement Report and Order must remember that the exclusion does not apply to the antenna. The applicant must consult the co-location agreement to determine if the antenna and associated equipment qualify for a Section 106 exclusion or require a full Section 106 review. This concludes the presentation. Thank you for your time and attention.
Thank you, Robert and Sarah. So we're just at the point of lunch, so I don't want to take any further time away from lunch, everyone. So we'll come back at, let's see what time. We're supposed to be back at 1:30. So everyone should come back and account for, if you're going outside, to account for the time it takes to get through security. So we look forward to seeing you at 1:30. Thank you. Welcome back, everyone. I know it was a short lunch, so I realize people are probably just kind of slowly coming back from lunch, and it's not a huge amount of time, so I appreciate those coming back and are anxious to hear from CEQ as myself as well. So thanks again for coming back this afternoon. I hope everyone had a nice lunch. So our next presentation will be an overview of the White House Council on Environmental Quality and PRM and amendments in the Fiscal Responsibility Act. I'm thrilled to introduce our guests here from CEQ, Amy Coyle, Deputy General Counsel, and Megan Healy, Deputy Director for NEPA, who will discuss these matters from the CEQ. Amy, I believe I'll be handing it to you. Is that correct? Or who's going first? Is it Megan? Okay, excellent. Okay, well, thank you, Megan.
Thank you. All right, this is a fancier microphone than we've been at recently, but it sounds like it's on, so great. Hello, everyone. Thanks for having us. Amy and I actually kind of do back and forth kind of presentations, so we'll be going back and forth. But to kick us off, do we have have are the slides up? There we go. There we go. Okay. If you can flip us to the next slide. Thank you. Just a little bit of background on both NEPA and CEQ. The National Environmental Policy Act was signed into law back in 1970 to promote environmental protection for present and future generations. And NEPA was recently amended back in June by the Fiscal Responsibility Act. And NEPA also established the Council on Environmental Quality, which issues regulations to implement NEPA. And then federal agencies subsequently issue their own agency NEPA procedures consistent with CEQ's regulations. Next slide.
So before we talk about the proposed rule, we just want to talk a little bit about the amendments to NEPA in the Fiscal Responsibility Act. So the first change I want to talk about are changes to Section 102, which is the provision that requires agencies to conduct environmental reviews on their actions. And so the provisions were modified to require consideration of reasonably foreseeable environmental impacts or environmental effects, including adverse effects that cannot be avoided if the action under consideration were implemented, as well as a reasonable range of alternatives that are technically and economically feasible and meet the purpose and need of the proposal. So these changes in the Fiscal Responsibility Act mainly codify things that have been in the CEQ regulations for a long time. The provision also specifies that agencies must analyze any negative environmental effects of the no action alternative. And further, 102.2 as amended requires agencies to ensure the professional integrity, including scientific integrity, of the discussion and analysis in NEPA documents and make use of reliable data and resources. The FRA added some new sections to NEPA. So Section 106 sets out procedures for determining whether NEPA applies and what the appropriate level of NEPA review is. New Section 107 clarifies the roles and responsibilities when there is more than one federal agency, as well as tribal, state, or local agencies involved in the action, including encouraging coordinated documents. This section also sets page limits and deadlines for completions of EISs and EIAs, environmental impact statements or environmental assessments. And it further provides a mechanism for project sponsors to obtain judicial review if an agency fails to meet a deadline and requires the agency to submit reports to Congress annually on any missed deadlines. Next slide. Section 107 of NEPA, also added by the FRA, provides that project sponsors may prepare environmental assessments and environmental impact statements under the supervision of federal agencies following agency-developed procedures. Section 108 addresses programmatic environmental documents and provides a presumption of validity for 5 years or longer if the agency reevaluates the analysis. Section 109 provides a process to allow an agency to adopt and use categorical exclusions established by other agencies. And I'll note that this provision has already been used several times by federal agencies, such as the Department of Transportation, which has adopted a categorical exclusion established by the Department of Energy for electric vehicle charging stations. Section 110 directs CEQ to conduct a study on NEPA, which is a study we're currently undertaking to inform how technology may improve transparency and expedite environmental reviews. And finally, Section 111 includes definitions for certain terms used in NEPA, including defining major federal action. Next slide.
Circling back a little bit on CEQ and our regulatory history, CEQ first issued its regulations to implement NEPA back in 1978, which were largely unchanged for over 40 years. And in July of 2020, CEQ issued a rule that substantially revised those regulations, which we commonly refer to as the 2020 rule. And back in April of 2022, we issued a final rule amending 3 core provisions of the regulations that were amended in 2020. We refer to that as our Phase 1 rulemaking. And then in July of this summer, we issued our proposed rule called the Bipartisan Permitting Reform Implementation Proposed Rule to make further revisions to the regulations, which we call Phase 2 for short. Next slide, please.
So before we start to talk about some of the proposed changes, I just want to talk a little bit about the overarching goals that guided the development of the proposed rule. And today we'll highlight in the presentation the proposed changes under these themes. So they include implementation of the Fiscal Responsibility Act, meaningful public engagement and transparency, improvements to environmental and climate change outcomes, improvements to environmental justice outcomes and respecting tribal sovereignty, informed and science-based decision-making, and lastly, an efficient process and regulatory certainty. Next slide. So before we talk about the specifics of the proposed rule, I just want to note that today's presentation does not provide an exhaustive list of the proposed changes, but that is covered in the preamble in the Notice of Proposed Rulemaking. And today we'll just focus on some of the key proposed changes. Next slide. So the first set of proposed amendments I want to highlight are those that implement those provisions of the Fiscal Responsibility Act I just mentioned. So to implement the statutory changes, we have incorporated the process for allowing agencies to adopt and use categorical exclusions established in other agencies' NEPA procedures. We've clarified the roles of lead, joint lead, and cooperating agencies. And where more than one agency is involved in a project, we have retained the requirement for a joint environmental impact statement, but are also proposing to require joint environmental assessments, records of decision, and findings of no significant impact, except where inappropriate or inefficient. Next slide. The proposed rule includes the 1-year deadline for completion of environmental assessments and 2-year deadline for environmental impact statements, along with page limits for each. NEPA now includes an explicit requirement to analyze the adverse effects of the no action alternative, and the proposed rule would require this in the section of the environmental impact statement discussing environmental consequences. And then, as I noted before, we have incorporated professional integrity, including scientific integrity and use of reliable data and resources throughout sections of the rule. Next slide. In the proposed rule, we consolidated in a single section of the regulations, which is 1501.3, the requirements related to making the threshold determination of whether NEPA applies to a proposed activity or decision, determining what level of NEPA review is appropriate, either a categorical exclusion, environmental assessment, or environmental impact statement, what the appropriate scope of the proposed action is for analysis in that NEPA document, and the context and intensity factors agencies should consider to inform their determination of whether the proposed action's effects are significant. So this approach incorporates the amendments to NEPA, restores certain aspects of the 1978 regulations, and maintains some of the 2020 rules concepts on threshold considerations. We have also added additional clarity on the roles and responsibilities of federal agencies, applicants, and contractors in the preparation of NEPA documents. Next slide.
Moving away from some of the NEPA amendments into just some of our other themes for our proposed changes, we've proposed in multiple places changes to support meaningful public engagement and transparency in the environmental review process, including adding purpose statements to describe both the purpose of public and governmental engagement. And when developing public engagement and outreach strategies, We're encouraging agencies to tailor those strategies to consider the needs of affected communities, including consideration of the primary language of affected persons and what the best format might be for a public hearing or meeting, recognizing that even in our post-COVID working environment, virtual is not always the best way to engage with the public, while also considering the scope, scale, and complexity of the proposed action to meet the agency's needs. Next slide, please. And to support additional transparency, we've codified a longstanding agency practice for agencies to invite public comment when they publish a draft environmental assessment. And we are also proposing to require that agencies add a unique identification number for environmental assessments and environmental impact statements to help both the public and other federal agencies track the progress of those documents from start to finish, including their supporting documents. Next slide. Further changes that we've proposed would require agencies to identify the environmentally preferable alternative at the environmental impact statement stage, allowing the public to be able to comment on it prior to the issuance of the record of decision. Currently, the requirement is only to identify it in that decision process. We've also proposed to reduce some of the requirements around specificity of public comments to reduce the burden on what public commenters have to submit, and require agencies to designate a chief public engagement officer to help facilitate engagement activities across the agency. Next slide.
Next, we'll turn to proposed changes that would improve environmental and climate change outcomes. In the introductory part of the regulations, which is part 1500, we are proposing to restore separate regulations addressing the purpose and policy of the regulations, including consideration of reasonable alternatives to the proposed action that would avoid or minimize adverse effects, and add as an example of such a reasonable alternative, one that would reduce climate change-related effects. The proposed rule also encourages agencies to consider the duration of effects when assessing the potential significance of those effects, and would require agencies to discuss relevant risk reduction, resilience, or adaptation measures in the environmental impact statement. Next slide. When preparing EISs, the proposed rule would require the analysis of environmental consequences to include consideration of disproportionate effects on communities with environmental justice concerns, as well as resiliency, adaptation, and climate-related effects. Where an agency relies on mitigation as a component of the proposed action, the proposed rule would require preparation of a monitoring and compliance plan to ensure that agencies are appropriately relying on mitigation in their decisions, and to address concerns that mitigation measures included in agency decisions are not always carried out or monitored for effectiveness. Finally, CEQ is proposing updates to various definitions to include specific references to climate change. Next slide.
Moving into the area of improvement of environmental justice outcomes and tribal sovereignty, in multiple places throughout the proposed rule, we have added language to ensure consideration of disproportionate and adverse effects on communities with environmental justice concerns and adverse effects on reserve rights of tribal nations in environmental reviews. In particular, one area these changes are made are within the list of context and intensity factors that agencies use to assess the significance of effects that Amy highlighted earlier. Next slide. We have also clarified that when considering involvement of a cooperating agency, special expertise does indeed include Indigenous knowledge, and we've also added references to environmental justice in multiple definitions, as well as added a definition for environmental justice in the regulations in alignment with Executive Order 14096 that was released earlier this year. Next slide. And finally, under this area, the proposed rule encourages agencies to adopt mitigation measures that are directed at effects that disproportionately and adversely affect communities with environmental justice concerns. Next slide. To support informed and science-based decision-making, we are proposing to restore direction for agencies to rigorously explore and objectively evaluate reasonable alternatives. And where the regulations discuss the affected environment and methodology and scientific accuracy sections of an environmental impact statement, changes we proposed emphasize use of high-quality information, including to describe reasonably foreseeable environmental trends, and examples of that include anticipated climate-related changes. Many changes in the rule are intended to ensure that agency decision makers are well informed and also tie back to the emphasis of professional and scientific integrity mentioned earlier when Amy was highlighting some of the changes from the NEPA amendments. Next slide.
The last set of changes we want to highlight include those focused on creating a more efficient process and promoting regulatory certainty. CEQ is proposing to remove provisions added by the 2020 rule that created litigation risks and jeopardized community input, including a provision that attempted to limit the ability of courts to provide injunctive relief when there are violations of NEPA. As I mentioned earlier, we have revised Section 1501.3 to consolidate and provide clarity on the entirety of the process for assessing NEPA applicability, the scope and level of NEPA review, and restoring the well-understood approach of using context and intensity factors to assess the significance of effects. We are proposing to require schedules for the development of environmental assessments and environmental impact statements, and encouraging coordination between agencies, project sponsors, and applicants, including placing an emphasis on consultation and concurrence on schedules, as well as early engagement with government agencies at all levels, federal, tribal, state, and local, where they have a role in the action or project. And we have combined the provisions on programmatic documents with tiering, codifying long-standing agency practices for using these tools to provide for more efficient reviews. Next slide. Regarding categorical exclusions, we are proposing to clarify that in the definition of categorical exclusion, in establishing CEs, agencies need to include consideration of the effects of both an individual application to a proposed action as well as multiple actions. We are also proposing edits to clarify the process for considering extraordinary circumstances when applying a categorical exclusion to a proposed action. The proposed rule would clarify that agencies can jointly establish categorical exclusions with other agencies, and the rule proposes a new mechanism for agencies to establish categorical exclusions through a programmatic environmental document or other planning process. Next slide. The proposed rule would provide additional clarity on when and how an agency can adopt another federal agency's environmental impact statement, environmental assessment, or categorical exclusion determination, with a focus on ensuring agencies are independently reviewing the document they are adopting. We have also provided a new section on innovative approaches to provide a new tool to encourage agencies to innovate in the NEPA process to address extreme environmental challenges. Next slide. Lastly, we are proposing updates to the section of the regulations addressing federal agency NEPA procedures, adding specificity on how agencies establish new categorical exclusions or revise existing CEs, and codifying elements of CEQ's 2010 guidance on categorical exclusions, such as requiring agencies to include procedures for reviewing their CEs every 10 years.
Next slide. And to close us out a little bit of where we are right now, the comment period on the proposed rule did end at the end of September, and we are in the process of reviewing and analyzing all of the public comments and using those to inform development and input on the final rule. If you are interested in viewing any of the thousands of comments, you can go to regulations.gov and the docket number is up there. You can also go to the simpler NEPA.gov And on that website, you'll find links to the proposed rule, the docket with some supporting information. We also have a new page on NEPA.gov under, it's called the Fiscal Responsibility Act Amendments to NEPA page that has some Q&A that we've started to answer questions we've received from agencies on implementation of the statutory amendments. And with that, I think we're turning it back for questions.
Great. Thank you very much, Megan and Amy. We have just one question, if CEQ can share expected next steps and anticipated timing for next steps in the rulemaking.
Well, I can sort of answer that question. So as Megan said, we are well underway of analyzing the comments that we received in the public comment process and working as quickly as we can to develop a final rule. And so our goal is to issue a final rule in early 2024, but of course we have to go through an interagency process. So that is the plan.
Thank you very much. I think we're done. We'll go on to the next session.
All
Thank
right.
you very much.
Thank you.
Thank you again, Megan and Amy, for joining us in person today. Hope it wasn't too inconvenient. Excellent. So our next presentation will be a nuts and bolts overview of Section 106 requirements, and it'll be presented by Ellen St. Onge, our Federal Preservation Officer. And how about... Thank you again, Ellen.
Okay, can you hear me? Okay, great. I think these are good microphones. I have a tendency to be a low speaker, but I think these are going to be good. But if I do get quiet, just, lift a hand or something and let me know. Okay. Can we get the slides? There we go. Okay, first slide, please. Thanks. I'm going to be presenting information on our 2 nationwide programmatic agreements, effects findings, the MOA process. I'll be talking a little bit about the electronic tools in this section. There's going to be another section later. Diane Dupert is going to talk about TCNS in more detail. And I'll talk a little bit about our Form 620 and 621. But following my presentation, Christine Heacock is going to be talking about preparing a submission packet, and so I'm only just going to touch on it. Next slide. So as previously described in the other presentations, the FCC is responsible for ensuring that its actions and undertakings consider and comply with federal environmental laws and regulations, including those that pertain to historic preservation under the National Historic Preservation Act. Next slide. The National Historic Preservation Act, or NHPA, which was passed in 1966, did a number of things. It created the National Register of Historic Places. It created the Advisory Council on Historic Preservation. And it required each agency to develop a historic preservation program and employ a federal preservation officer. Section 106 requires federal agencies to consider the effect of their undertakings on properties listed on the National Register, as well as those that are eligible for listing. It defines undertaking to include, among other things, projects requiring a federal permit, license, or approval. And the FCC has consistently treated tower construction as an undertaking under NHPA due to its relationship to licensing and antenna structure registration. Next slide, please. So the ACHP rules establish the Section 106 review requirements, but they also allow for agencies to create program alternatives which are historic preservation review processes specific to that agency's undertakings. So in August of 2000, the ACHP established a telecommunications working group to help develop streamlined Section 106 process for wireless facilities. The Commission has entered into 2 nationwide programmatic agreements with the ACHP and the National Conference of State Historic Preservation Offices, or NCSHPO. And Robert did talk a little bit about the streamlined review requirements under the 2001 co-location NPA and the 2005 wireless facilities NPA. And those establish the applicant's Section 106 obligations under the FCC's rules. Next slide. For the Section 106 process, the wireless facilities NPA broadly defines applicant to include commission licensees, permittees, or registration holders. Applicants or prospective applicants for wireless or broadcast licenses, authorizations or ASR, and their agents, employees, and contractors. The FCC's rules delegate Section 106 obligations to the applicant, and they have to follow those streamlined review requirements of the co-location NPA and the wireless facilities NPA. An ACHP delegation letter allows applicants and their consultants to act on behalf of the FCC, to initiate review, to prepare and distribute reports and findings to the SHPOs, tribes, and consulting parties prior to construction. Next slide. Okay. Everyone here already knows this, but I'm going to say it again. You cannot construct before completing the environmental review and the Section 106 processes. And that includes site clearing, vegetation removal, any ground disturbance at all, or any digging other than those outlined for doing the environmental assessments before ascertaining, before completing Section 106 or the NEPA checklist. And the Competition and Infrastructure Policy Division, CIPD, we are the first line of environmental review, and you've already heard from our Enforcement Bureau that works jointly with us to ensure that environmental processes are being followed. Next slide. So the NPAs. I'm going to talk about some general provisions in the NPAs that are important to mention. So the programmatic agreements do not apply on tribal lands. The exception is if the Tribal Historic Preservation Office or another tribal government agrees that they would use the NPA. They also don't apply on other federal lands. However, the land managing agencies may avail themselves of our rules by following the Broadband on Federal Lands Program comment. So that also allows other agencies to use a streamlined process. The NPAs encourage applicants to hire the appropriate Secretary in the Interior qualified professionals to support the Section 106 review. As I've been introduced, the FCC employs a Federal Preservation Officer, that's me, and a Deputy FPO, that is Christine Heacock, and she'll be presenting next. She's back there now, to assist with the Section 106 process, and feel free to get in touch with us. And although we delegate much of the responsibility for Section 106 reviews to the applicant, the FCC becomes involved in certain situations. We may become involved if we're needed or requested to resolve disputes between parties on various issues. We may become involved if requested by a tribe, and we do become involved when there are potential adverse effects identified to historic properties. Next slide. So under the co-location NPA, most antenna projects are excluded on existing towers from routine NHPA Section 106 review. And Robert did go through in some detail what what those various requirements are to meet the exclusion. Co-location on a tower constructed before March 16th, 2001 is ordinarily excluded from review, provided the antenna will, one, not substantially increase the size of the tower. Two, the tower has no pending complaints or unresolved adverse effects. Co-location on a tower constructed after March 16th, 2001 is excluded, provided that, one, it has completed Section 106 review prior to the construction, that the antenna will not substantially increase the tower size, and again, that there are no pending complaints or unresolved adverse effects. Next slide. In 2016, an amendment to the co-location NPA added some additional exclusions. It excluded co-locations in buildings and structures regardless of age that are not historic or in historic districts. And again, prior to that amendment, the co-location NPA did not allow exclusions for co-locations on buildings and structures more than 45 years old. It excludes co-locations on or in buildings or structures that are historic or in or near historic districts, as long as they are not National Historic Landmarks and they meet the size and visibility limitations and they require no new ground disturbance. It excludes co-locations on utility poles or transmission towers in or near historic districts, again, that meet size and visibility limitations and require no new ground disturbance. And the co-locations on lighting structures, if the SHPO agrees that those are non-contributing elements to a historic district. Next slide. There was an additional amendment to the co-location NPA in 2020. It eliminated Section 106 review for certain co-locations that involve a limited expansion of the boundaries of a tower site. So if the co-locations do not expand the boundaries of the current site by more than 30 feet in any direction or involve excavation outside of those boundaries, then it may qualify for Section 106 exclusion, provided all the other applicable size and limitations fit. Next slide. Other things to know about the FCC Section 106 review. The SHPO has 30 days to concur or comment on the applicant's submittal of Form 620 or Form 621. If the SHPO concurs with the finding of no historic properties affected or finding of no adverse effect on historic properties, and if consultation with the tribes has been completed, then that concludes the Section 106 review without FCC weighing in. If the SHPO does not concur with the applicant's findings, or if the project is going to have an adverse effect on a historic property, then consultation will continue. If there's a failure to concur, the parties must make a reasonable and good faith effort to resolve the disagreement. But if it can't be resolved, they can submit the matter to the commission. Next slide. The FCC's 2005 Wireless Facilities NPA applies to the construction and modification of facilities, which can be either towers or antennas. Towers are considered structures built for the sole or primary purpose of supporting licensed or authorized antennas, associated fencing equipment, and so forth. The NPA excludes from Section 106 review tower enhancement, replacement, and temporary towers, and it excludes towers in industrial parks, malls, and communication or utilities right away, provided that the site is not in or near historic properties. The NPA clarified the role of applicants, SHPOs, and consulting parties, and that NPA established our tribal outreach requirements, which we will be talking about in another section in more detail. Next slide. Okay, I'm going to be talking a little bit about effects and resolving effects. A conditional no adverse effect was introduced to revisions of the ACHP regulations in 1992. It is allowed under the FCC rules and the Nationwide Programmatic Agreement. It allows the SHPO to condition the recommendation of no adverse effect by requesting certain steps that will reduce or eliminate the adverse effect. And the benefit of this, of course, is that it does not trigger a memorandum of agreement. So that can shorten the process. Next slide. Okay, adverse effects. So when an applicant determines that a project will have an adverse effect and the SHPO or the TIPO concur, then the applicant must notify the FCC and they have to notify the advisory council. The advisory council does not always participate in a project, but it is a requirement to notify them when there's going to be an adverse effect and request their participation. And in those cases, the applicant is responsible for submitting the documentation and the request to participate to the advisory council. So an adverse effect does not necessarily stop a project, but it will require additional steps. To go forward, the applicant will have to provide an alternative analysis, which I'm going to discuss in the next slide a little bit, and mitigation plan. And if the Form 620 or the Form 621 identifies an adverse effect, those two elements must be included in the original documentation to the SHPO and to the TIPO, or TIPO, depending. Okay, next slide. So an alternatives analysis is an important step. It demonstrates to the SHPO, the TIPO, the FCC, and consulting parties that the applicant has considered other sites. Some of the things you need to do are provide maps that show these other sites, provide a narrative that explains the reason for the preferred site, and but I will say the applicant may request that proprietary information be restricted to the FCC. Next slide. So as mentioned, the applicant will also have to develop a mitigation plan, and we have developed a list that is just some suggestions, by no means a complete list or comprehensive, but some of the initial things you should look at are lowering the height of the tower, reducing the size of the communications gear if that's visible and would, contribute to the adverse effect. Painting the tower and gear to make it more stealth, or installing stealth towers. So there were some examples shown in the previous presentation how to make it look less obvious that there's a tower. There can be plantings that hide the facilities, and if those if these, the lessening of the adverse effect isn't necessarily all you can do. You can provide a benefit to the affected historic property. Next slide. And so talking about what that means and what those benefits could be. There's a variety of things that you can do, and you may be probably familiar with some of these. If it's not already on the National Register, you can prepare a National Register nomination form, or perhaps update an existing listing if it's been a long time since it's been nominated. If you could do a Historic American Building Survey, HABS, or an engineering record, HABS-HAIR. And we don't have it listed up there, but there's also Historic American Landscape Studies. So there's documentation, basically. You can look for ways to provide interpretation of the historic property, possibly developing, installing wayside signs or historical markers, other interpretive efforts can include brochures or cell phone tours, and there's probably a lot of other ways that you can have a public interpretation element to the mitigation. And I want to stress that it's important to work with the SHPO and the local community to identify what the appropriate mitigation measures are, because they may have ideas other than the ones we've listed here on what they feel would be beneficial for their community or what would be appropriate for that specific resource. So they may, it's important to keep the consultation process open and listen to what those ideas are. Next slide. So where there are adverse effects, the applicant will also have to develop a memorandum of agreement. The applicant should be negotiating this with the SHPO and the TIPO and the consulting parties on the stipulations for the mitigation. As mentioned, that's part of the consultation process. The applicants should prepare the MOA starting with the FCC template that's available on our tower and antenna website. Although you're not completely restricted to use of that, that's a good starting point. Draft MOAs do need to be sent to the FCC for review, and that's our address, s106.moa@fcc.gov, and that's where we will intake for review. All MOAs are reviewed by the Deputy Federal Preservation Officer, the Federal Preservation Officer, and an attorney. And when developing the MOA and the mitigation measures, most MOAs don't necessarily require that mitigation is complete prior to construction. So once the MOA is signed, that's a legally binding agreement that the mitigation measures will be carried out. And as long as it's not, say, an archaeological excavation on the site, which would slow down construction, if it's an interpretive measure or a documentation measure, those can be completed while construction is going on or after construction. The MOA should include a reporting, but they should reporting requirements so that when those mitigation measures are complete, all parties to the MOA will be notified. So that would be part of the MOA process. Next slide. Okay, I'm going to talk a little bit about FCC's electronic tools. And I'll say we're going to talk about the tower construction notification system just a little bit here. We're going to be talking about it when we get into tribal outreach, and we're going to have a presentation from Diane Dupert working with TCNS. So we're covering TCNS a lot this afternoon. It's a voluntary system developed to facilitate tribal Section 106 participation. So the tribes and Native Hawaiian organizations can use our system to designate the geographic areas of interest. And the FCC does protect this information as confidential. So when you put your information into the system, our system will automatically forward the information to those tribes, but we don't have, like, say, maps that show where the areas have been, where each tribe has indicated their area of interest. Tribes may respond through TCNS if interested in further participation or outside of TCNS. And it's really important, and you'll probably hear this a couple times, but TCNS provides a notification to the tribe. It does not substitute for the Section 106 process, and it does not constitute government-to-government consultation. But if the tribe does disclaim interest in that point, it can complete the process and not require further. Next slide. Okay, our other electronic tool is E106, can be found at that web address. I'm not going to go through that, but there it is if you need it. It's the electronic database used to file the FCC forms that support the Section 106 process. And I just want to say that applicants first notify the tribes using TCNS, and then they file their Form 620, 621, and that triggers the shot clocks for the various consulting parties, the tribes and the SHPO. Next slide. So again, I'm just going to touch on a few high-level points regarding preparing Form 620 and 621. Form 620 is prepared for new towers, 621 for co-locations. We have the instructions for using E106 are found in the Section 106 Tools link on the tower and antenna siting page. And we've got the link there. I think we probably had it in a few other presentations as well. And also our procedures for are also detailed in Section 7 of the 2005 Nationwide Programmatic Agreement. And as I mentioned earlier, the NPA encourages the use of Secretary of the Interior qualified professionals to identify historic properties within the area of potential effects, or the APE. Next slide. Questions. So that concludes.
Thank you, Ellen. So over here, we have a few questions that we're going to try and address. Also, as a preliminary matter, throughout the day, we've gotten several questions about whether the slides are going to be available after the presentation. They will be on the website along with the video, so you can capture us again and quote back to us later, which of course has happened in the past. So don't want to give you any ideas. Anyway, it will be available after the presentation today. So another thing I wanted to note, this is going back to Mike Smith's presentation from earlier today, and there was a lot of discussion about temporary towers. And you know, there's a 60-day period and there's no exceptions. However, we did note there is one exception here, and I want to read it out to you, but it's very limited in fact. And it's not in our rules, but it's in a commission order. More specifically, it's in the commission's 2014 infrastructure order about acceleration of broadband deployments by improving wireless facility siting. And so in that order, in paragraph 130, it says that we will permit a single extension of up to 60 days and only upon a showing that the need to keep the exempted temporary tower in place beyond the initial 60 days is due to changed circumstances or information that emerged after the exempted temporary tower was deployed. So it's a very specific exception. And so if the applicant believes that they meet this exception on the temporary tower exclusion, they would need to file something with us. And of course, you can contact the staff at the commission on this particular exception, but I wanted to note that to everyone and call that out. And specifically, again, it's paragraph 130 of the commission's 2014 infrastructure order, okay? Next, another question that came in about co-locations on non-compliant towers that did not go through Section 106. So again, this is co-locating on a non-compliant tower. That never happens, right? Although most co-locations are excluded from Section 106 review, a proposed co-location is not eligible for an exclusion if the underlying tower was built after March 16th, 2001, and it did not go through Section 106 review. In such cases, the co-location requires full Section 106 review. On the other hand, if a tower was built before March 16th, 2001, and did not undergo Section 106 review, a proposed co-location is excluded from Section 106 review, provided that it satisfies the other conditions required for an exclusion. Again, you can play that back later. So we have one more question that Carrie Hicks is going to take.
Yep, so we received one more question about the co-location exclusions and the interplay between Section 106 and NEPA. So in general, whether a Section 106 excluded co-location also has to go through NEPA. So in general, co-locations are categorically excluded and do not require an EA, even if it triggers one of the factors on the checklist, except for historic preservation or human exposure to RF. I think that was covered in Paul's presentation. So applicants do have to determine both whether a Section 106 exclusion applies and whether a NEPA categorical exclusion applies. An EA could be required, however, in response to a request for environmental review or on the Bureau's own motion, as we discussed previously in some of the earlier sessions today.
Great. Okay. Thank you, Ellen. See, you get an applause. She should bow. Thank you. Excellent. Okay, our next panel. We're going to walk through sample Section 106 submission packet, which will be presented by Christine Heacock, the FCC's Deputy Federal Preservation Officer. I know this one's in high demand, Christine. So, well, this is Christine's personal project, making sure the forms and the submission packets are correct and everything as it should be. So Christine's going to do a very thorough job here today explaining what's expected in these submission packets. Okay, thank you again, Christine, for doing this.
All right. Thanks, Garnet. All right, good afternoon, everyone. Today I will present, as Garnet said, a sample submission packet to provide some clarity on our requirements. And during this review, we will go over each page of the submission packet. And as Ellen mentioned, a Form 620 for new towers, a Form 621 for co-locations. And we'll also go over the requirements for each of the attachments to this form. And some of the issues that I cover in this presentation are because they've come up in the past, so we're providing some clarification. If we could get the slides up there. All right, and next slide. All right, so starting with page 1, general information. So, as mentioned before, so the applicant is the licensee or tower builder. They will have a different FRN or FCC registration number than a consultant. Please fill out your sections completely and ensure that the person listed on the form is available via the contact information that's provided on the form, because when we run into an issue and then we go to contact them and either the email address doesn't work or the person's that's not the correct one, it creates some roadblocks. So please ensure all the information is accurate. Next slide. All right, so consultant qualifications. So even if the principal investigator does not meet the Secretary of Interior qualification standards, so a lot of times it's like a project manager or someone, there should still be someone in this process and on the form that meets these standards. I will note that there are certain provisions within the wireless facilities MPA that state which tasks must be completed by a professional who meets the SOI qualification standards. I've listed some of them up there. They include determining whether or not a historic property is no longer eligible for the National Register, identification and evaluation related to archaeological resources, and also the finding that a field survey is not required for a particular project. Next slide. All right, site information. So please ensure that the project is tied to a TCNS number. So as Ellen mentioned in her presentation, so the TCNS notification kind of tees it up for everyone that a submission packet is coming. So please make sure that that field is populated, and please make sure it is tied to the correct TCNS number for that project. I put this one in red. Please fill out the description of the project that clearly conveys the proposed work. So what happens is sometimes folks will put in their own particular company's identification number for the project. So it'll be like a series of letters and numbers. Well, I don't know what that means, and neither does the SHPO or anyone else. So it's very nice to have some sort of, even as just a proposed, as I have here, a proposed support lattice tower with the height, that goes a long way. And keep in mind that the people that are reviewing these, the SHPOs, the TIPOs, or FCC staff, so if it's a case where there's a finding of no adverse effect and then it gets escalated to the FCC for review. We've not been at the site, so what we're trying to do with these submission packets is create as clear of a picture as possible so that a desktop reviewer can understand what's going on. That'll be very helpful. Next slide, please. So then your determination of effect. So for FCC undertakings, there are two areas of potential effect. So there's the APE for direct effects and indirect effects. That is also referred to as visual effects. And please note that the determination of effect should match throughout the E106 system and all the supporting materials in the submission packet. So for instance, if your determination of effect packet says no historic properties, and your Form 620 says no historic properties, those should match. We shouldn't have different determination of effects throughout the packet. Next slide. All right, so please make sure to contact tribes and Native Hawaiian organizations via their preferred means of communication when you submit the project in TCNS. And as mentioned, Diane will go over this. There's the notice of organization, so applicants will get that back, and it'll indicate the tribes that are interested in that area and also their means of communication. So, whether it's email, whether they have a response that says, please submit it to this particular email address or mail it to this address. So, we have that tool in there, so we ask that people please use that. And also keep in mind, tribes have a right to seek government-to-government consultation, and in these instances, they work directly with the FCC staff. And as a general note, while we're speaking of tribes, when a tribe indicates an adverse impact or they request monitoring or they indicate that there's a significant site that may be impacted, please don't stop communicating with them. Still continue to engage unless they've requested government-to-government consultation, and at that point, we'll take over. Next slide. So historic properties. So of course, identify all historic properties in the two APEs. And also a note that if there are more than 10 historic properties in either of the APEs, you are required to attach a cultural resources report instead of listing the historic properties on the Form 620 or 621. They can get really long. If you list them out, it's easier to just put them as an attachment, so that's why we have it there. Next slide. All right, local government involvement. So local governments are consulting parties by right in the Section 106 process. And Section 5A of our NPA does state that on or before the date that the applicant submits the submission packet, they shall provide the local government, and that is whoever has primary land use jurisdiction over the site of the planned undertaking, with written notification of the planned undertaking. The written notice to the local government and to the public shall include the location of the proposed facility, including its street address, a description of the proposed facility, including its height and type of structure, instructions on how to submit comments regarding potential effects on historic properties, and of course the name, address, and telephone number of a contact person should they have any comments. Next slide. So other consulting parties. So Section 5D of the NPA addresses consulting parties, and it also says that a SHPO and TIPO may make available lists of other groups, including Indian tribes, NHOs, and organizations of Indian tribes or NHOs, which should be provided notice of the undertaking to be located in a particular area, and Section 5G 1 through 2 describes what consulting parties are entitled to. So they are entitled to receive notices, copies of submission packets, correspondence, and other documents provided to the SHPO or TIPO in the Section 106 review, and they should be provided an opportunity to have their views expressed and taken into account by the applicant, the SHPO or TIPO, and where appropriate by the commission. Next slide. So here are some images of a couple of the pages that differ a little bit on the Form 621. So you'll see over there it says co-location information. So you'll have this field that says, what exactly are you co-locating on? Write a little description. So in this example, we did a water tank. You'll have construction completion year, and then whether or not it has previously been subject to Section 106 review. Next slide. And then another thing that differs, clearly indicate whether construction has started. If construction has started, you're probably in violation of our rules, so you should probably stop what you're doing and let us know. And please ensure, again, that the determination of effect is consistent throughout the form. Next slide. And then the other page is a designation of the SHPO or TIPO. So please designate the appropriate SHPO or TIPO office. And by signing the form, the applicant is certifying that the statements listed in the section are true, complete, correct, and made in good faith. All right, next slide. So attachments. So the attachments to the Form 620 or 621 are the most frequently incomplete components of a submission packet. Parties should submit all required information for each submission packet to include maps and photographs. And please ensure all information provided makes the undertaking clear to a reviewer. And I'm sure you're shocked to hear that we're directing you to the tower and antenna siting page to see the requirements for this. Next slide. Okay, so first attachment is resumes. So the resume should clearly demonstrate that a professional meets the Secretary of Interior qualification standards for the aspects of the Section 106 process specified in the MPA that require this qualification. I will note, we understand that sometimes people will confer with the SHPO to get an idea of whether their tower site's viable, but these discussions do not eliminate the need for a qualified professional to apply the criteria of adverse effect on behalf of the applicant. There have been instances where a form is submitted and then folks say, well, I talked to the SHPO, they're qualified, right? I'm like, that is correct, they are qualified, but we do need applicants and their consultants to, because what's going on here is the applicant is making a determination of effect using our Form 620 or 621 to then send it to the SHPO for review, see if the SHPO concurs. They say whether they concur. I appreciate teeing it up to make sure that the SHPO is probably going to say yes. So by those discussions, but it doesn't substitute the need to go through the process. So appreciate the extra step and the extra credit, I guess, that they're doing, but that doesn't eliminate the need to hire professionals to meet the qualification standards. Next slide. All right, photographs. So I recall this was a very popular topic last year. And to reiterate, so we have our established photograph requirements. So photographs should be in color. And of course, unless there's cases where there's no historic properties identified, the photograph should be in color, marked to identify the project, keyed to the relevant map, and dated. They need to be taken from the tower. If you're doing from a tower, they should be taking it from a tower site to show the views from the proposed location in all directions. So that's north, south, east, west, with each direction identified in the caption. And if there are any eligible or listed historic properties in the APE, please photograph those. If any historic properties are visible from the proposed site, please submit a photograph looking at the proposed tower site from each historic property along with the approximate distance. Please do not use Google Street View to substitute for photographs. So SHPOs, TIPOs, tribes, consulting parties, and the FCC rely on the accuracy of photographs to understand the physical context of the proposed tower or co-location. Now, we do recognize there are certain circumstances where obtaining a photo can be difficult for safety reasons. So in these instances, Google Street View may be acceptable. However, in the majority of circumstances, a photograph is feasible. Next slide. So I thought I'd illustrate this point with a picture. So this is in the town that I live in. And the image to the left is from Google Street View. And if you notice, it says May 2021. And then to the right, that is a photograph taken on August 2023. So you can see they look nothing alike. These site conditions are completely different. So yeah, would hope that that would illustrate my point that, I mean, now there's a bridge there, there's a whole new traffic pattern, things are completely different. So that is why Google is not always the best, well, it's not really the best tool to use. There's also been points in submission packets where taking Google photographs from the different vantage points are from Google data from different years. So it's like, in one year there's a tower there, and another year it's not there, and then in another year it's like, okay, this is clearly not giving us a clear picture. So that's why we like to emphasize this point. Next slide. All right, map requirements. So please make sure to clearly identify your APE in the maps. We do list these requirements, one or more 7.5-minute quad topographic map. Please identify the area of potential effects for both direct and visual effects. And if it's copied from the original, include a key with the name of the quad and date. Show the location of the tower site and any access roads. Show the location of each of any identified historic properties listed in your form, and include keys or any symbols or colors or any other identifiers, and please submit color maps when possible. Next slide. As I said, the areas of potential effect, so there's 2 for FCC undertakings. You would need to describe the APE for direct effects and explain how it was determined, and then the APE for visual effects and explain how it was determined. And again, please clearly illustrate these. Next slide. So this is my attempt to go ahead and show you what I'm talking about. So the AP for direct effects, as you can see, the little blue area would show, hey, this is where the area of ground disturbance is. The little dot would be our pretend site. And then, that would be, I guess, the little compound and then some sort of access road. So that gives us a good idea of where the ground disturbance will take place. Next slide. And then AP for visual effects. So in this one, there's our sample site, and then the little purple boxes are theoretical historic property. So that lets us know the distance between the proposed site and a potential an identified historic property. Next slide. All right, so please key your photographs so we know from what vantage points they're coming from. So per the Form 620 instructions, photographs should be in color, marked as to identify the project, and keyed to the relevant map. And this would be that map. Next slide. So additional site information, some recommendations. So we'd like to, for folks to describe any of the additional structures, access road, utility lines, plan for the site. And also, site plans are usually included in this attachment, and they are extremely helpful in visualizing the proposed work, especially for co-locations where you have pre-co-location and post-co-location. It makes it very easy to assess. Site plans and as I said, before and after significantly help in review, and also, of course, with new towers as well. Again, the more detail, the better. Next slide. All right, so for indicating proof of tribal consultation and Native Hawaiian organization involvement, please include the relevant documents pertaining to tribal consultation. So acceptable documents can include, but are not limited to, copies of emails, copies of letters, and attaching the notice of organizations. And then applicants and consultants should take care to not disclose locations of tribal significance. Next slide. All right, so historic properties for direct effects. Again, please clearly describe the AP for direct effects. And the AP for direct effects is limited to the area of potential ground disturbing and any property or any portion thereof that will be physically altered or destroyed by the undertaking. Pursuant to Section 62A of the MPA, applicants shall make a reasonable and good faith effort to identify above ground and archaeological historic properties, including buildings, structures, sites, objects, and historic districts that lie within the APE for direct effects. And such reasonable and good faith efforts should include a field survey when appropriate. The MPA also states that identification and evaluation of historic properties within the APE for direct effects, including any finding that an archaeological field survey is not required, should be undertaken by someone who meets the SOI qualification standards. And an archaeological field survey is required if a tribe or Native Hawaiian organization provides evidence that supports a high probability of the presence of intact archaeological historic properties within the APE for direct effects. Next slide. Make sure to list all properties identified within the APE for direct effects. You're required to provide the name and address of each property in the APE for direct effects, not listed in Part 8, that was the previous slide, that the applicant considers to be eligible for listing in the National Register, and then for each property described how it satisfies the criteria for eligibility. And for each property that was specifically considered and determined not to be eligible, describe why it does not satisfy the criteria for eligibility. And then please, describe your methodology that was used for identifying historic properties in the APE. And if there was no archaeological field survey, please provide a report substantiating one of two things, that the depth of the previous disturbance exceeds the proposed construction depth, and that's excluding footings and any other anchoring mechanisms, by at least 2 feet, or geomorphological evidence indicates that cultural resource-bearing soils do not occur within the project area or may occur but at depths that exceed 2 feet below the proposed construction depth. Next slide. So historic properties for visual effects. So Section 61A of our MPA requires that applicants review publicly available records to identify historic properties within the APE for direct effects. So that would be properties listed on the National Register, properties formally determined eligible for listing on the National Register, properties that the SHPO, TIPO, or TIPO certifies are in the process of being nominated to the National Register, and properties listed in the SHPO or TIPO's inventory that the SHPO has previously evaluated and found to meet the National Register criteria, and they are identified in the SHPO's inventory. The section also requires that applicants identify historic properties that have religious or cultural significance to tribes and Native Hawaiian organizations. Next slide. So identification of historic properties. So based on the sources that I spoke of earlier and public comments received pursuant to Section 5 of the MPA, applicants should include in the packet a list of properties as apparent historic properties within the APE for visual effects. And then during the review period described in Section 7A, the SHPO may identify additional properties in their inventory located within the APE. That came up last year. They asked, what if something's not on the, not eligible or listed yet? It's like, well, there is that provision for SHPOs to identify those to applicants. And then, also the SHPO can advise the applicant that a previously identified property is no longer eligible for the National Register. Next slide. Right, so local government involvement. So if you've contacted a local government or and they've been invited to become a consulting party, please list that government agency contacted and provide a summary of the contacts and any copies of relevant documents like correspondence or notices. If a local government agency will be contacted but not has been to date, explain why and when such contact will take place. Next slide. So So for public involvement, the submission packet should include the following: either copies of any relevant correspondence or other documentation used to invite public involvement in the project, so legal notices, letters, or public meetings, either a copy of the public notice after publication or an affidavit that will satisfy this requirement, and then any comments received. I will say it's more helpful to show that the public notice has been published or an affidavit. If you include a document that just says, we will publish it in this paper, and that's it, it may turn out that that just didn't happen, someone missed a step, and then, you haven't met your public notice requirement for Section 106. Next slide. All right, and then state-specific forms. A state-specific form may or may not be required. Most of the time it isn't. And I will emphasize that these state-specific forms do not substitute the need for a complete Form 620 or 621. And then next slide. Here are some resources. So a lot of that information can be found on the actual instructions for filling out a Form 620 or 621 on the tower and antenna siting page. We have the instructions for each of the forms, and then there's even a template for providing local public notice. And next slide. And that's it. That's all I got.
All right, thank you, Christine. And so we have 2 questions, which I'll answer up here. The first is why filings referred for FCC review following a SHPO expiration to a no adverse effect remains indefinitely in FCC review after the 15-day review period expires. And so in cases where a no adverse effect determination has been referred to the FCC for review, E106 will send an automatic notification when the 15-day review period has expired. The applicant must then go into the E106 system and close the project. In some cases, the system may not show the button to close out the project, and in those cases, the applicant can submit a request to the FCC to close out the project at fcc.gov/WTB-help. So that's fcc.gov/WTB-help. And then the second question is, if an MOA, a memorandum of agreement, is completed for an adverse effect, does an EA still need to be completed if the only adverse effect was to historic properties? And the answer is no. All right, and I think that'll do for this panel. Garnet? Yeah. Thanks again, Christine.
Great. Christine's gonna stay here. And the next panel, we will be talking about tribal outreach requirements under the Nationwide Programmatic Agreement, and it'll be presented by Ellen St. Ange and Christine Heacock. Ellen, I think you're next. I'll hand it over to you. Thank you.
Yes, thank you. Okay, can I get the first slide? Okay, thank you. As Garnet mentioned, we were talking about tribal outreach under the Nationwide Programmatic Agreement. First slide. Yeah, so in the previous sections, we have described how the NHPA requires federal agencies to consider the effects of their actions on historic properties. And those historic properties can include places where tribes attach religious and cultural significance. And I would say, there's a definition in NHPA. I don't know that I need to read that, but it's important to recognize that tribal resources were not considered eligible for the National Register of Historic Places until 1992. And at that time, the advisory council, there was an amendment to the NHPA that recognized and expanded the roles of Indian tribes and Native Hawaiian organizations. And that amendment also was when they first established the Tribal Historic Preservation Officer Program, or THPOs. And you probably know THPOs can assume the responsibility of the state historic preservation officers for projects on tribal lands. and they participate in the Section 106 reviews of projects off tribal lands as consulting parties. And when talking about tribal outreach, it's just important to understand that consultation with the tribes is necessary to identify tribal historic properties that other cultural resources professionals are not qualified to identify those. So it's not, you can't cover it with just an archaeologist and an architectural historian. You have to consult with the tribes. Next slide. So in terms of who you consult with, the Section 106 regulations make a distinction between projects on tribal land and projects off tribal land. If a project is on tribal land and if they have a formally designated tribal historic preservation officer, which not all tribes do, then the agency consults with the TIPO instead of consulting with the SHPO regarding undertakings affecting tribal resources on tribal lands. If the tribe does not have a formally designated TIPO, the agency consults with both the SHPO and a representative designated by the tribe regarding the tribe's resources. For projects that are off tribal land, the agencies consult with all tribes that attach religious and cultural significance to historic properties within the AP that may be affected by undertaking. And it's, you know, again, these resources do not have to be on tribal lands. They can be anywhere that the tribes can consult regarding those historic properties. Next slide. So under Section 106, agencies are required to identify Indian tribes and Native Hawaiian organizations. And under our NPA, we agree that the applicant can use the TCNS system or some other system to notify tribes who have included the site within their geographic area of interest. And again, I want to point out that the tribe's area of interest may be quite broad and include current lands, ancestral lands, ceded lands. It may include where they've been removed, that trail that they've walked. So it can be a broad category of interest. The FCC does consider the use of TCNS to be a reasonable and good faith effort to identify tribes. When contacting tribes, again, the applicants must follow tribes' preferred communication preference. A lot of them will communicate by email, but there are still some tribes that are only going to be willing to receive information through the U.S. mail. And I'm sure you all know this, but in all communications with tribes, applicants should be sensitive and respectful. And the applicants under the NPA, we require them to provide information reasonably necessary for the tribe to evaluate whether there are historic properties of religious or cultural significance that could be affected. And they have a reasonable opportunity to respond, and that we consider that to be 30 days upon receipt of the information. Additionally, applicants need to make a reasonable effort to follow up. Next slide. So, of course, the best outcome is for applicants and tribes to reach an agreement on the presence or absence of affected historic properties. If you can do that without involving the FCC, that's great. If the tribe does identify a historic property, the applicant invites the tribe to become a consulting party and notifies the FCC. If the project will affect the historic property, the applicant consults to avoid, minimize, or mitigate the effect. And that can happen, the applicant can work with the tribe directly, or if the tribe requests it, they can work through the FCC. Next slide. So again, the TCNS is a voluntary system developed for the FCC in order to facilitate identification of and contact with potentially affected tribes. And, you know, the tribes and the Native Hawaiian organizations designate their geographic area of interest, which the FCC does protect, as confidential information. Once the applicant enters the basic information about the project, that information is automatically forwarded to the tribes that have expressed interest in that area. At that point, the tribes may indicate an interest, they may indicate no interest in further participation, and I think I said this before, TCNS provides notification. It does not substitute for the Section 106 process or the government-to-government consultation unless the tribe has indicated that they are not interested. Next slide. So following TCNS notification, the applicant must then follow up using the E106 system to start the review clock that will enable referral of non-responsive tribes when Form 620 or 621 is prepared for SHPO review. So, and I did want to mention there are some projects that are excluded from SHPO review under the programmatic agreement in sections 3D and E. These include facilities located in industrial parks, strip malls or shopping centers, and facilities in utility or communication corridors rights of way. But it's important to note that although they're excluded from SHPO review, they still require tribal participation. So to deal with that, the Commission's second wireless infrastructure report and order of March 2018 established an alternate submission packet requirements for those cases when a Form 620 or 621 is not being prepared for SHPO review. And the alternate submissions must include contact information, project coordinates and mapping, facility site description, and aerial and site photographs. And for these packets, again, you know, the applicants have to consider the tribe's preferred means of communication. They can be submitted electronically, or they may need to be put in the mail. Next slide. So this slide addresses some of the issues that have come up with using TCNS. In 2018, the second report and order clarified that a number of Section 106 tribal participation requirements. It addressed tribal review fees, information requests, tribal review timeframes, and contracting issues. So understand that these continue to be issues for applicants. Disagreements with tribes about any of the requirements should be referred to the FCC by emailing tcnshelp@fcc.gov. And while the report and order clarifications do, you know, they provided clarifications on a number of things, they do reaffirm an applicant's responsibility to identify tribal historic property. So that continues to be an important responsibility. So non-responsive tribes may be referred through the TCNS system once they've had 30 days to review the Form 620, 621, or the alternate submission packet. Tribes that respond initially through TCNS and then go silent, or if they're otherwise not referable through TCNS, can be referred at the link there, www.fcc.gov/TCNS-manual-referral by following the instructions, and I'm not going to try and say that. There's a link that's located at the bottom of the page. Not useful.
You said the important one.
I said the important one. Once you get to that page, there's a link, and you can get to those instructions. Next slide. So response timelines. The review clock begins to run on the date the tribal nation can be reasonably expected to have received the required information. which electronically, that's 30 days, but if it's going in the mail, that's 35 days, because there needs to be some time for them to get the information. Applicants should convey the Form 620, 621, or alternate submission packet to the tribe, again, following their preferred means. And this, their preferred means may be described in the notice of organizations, or they may have to be expressed directly by the tribe to the applicant. Some of them have it in, some of them may not. And when they receive that accurate submission packet, that starts the clock. And uploading the Form 620, 621 to E106 system starts the referral clock, and it generates a notification to the tribe that the information is there available to review. The alternate submission packets for those excluded projects are uploaded at the time of the TCNS filing, and that starts that 30-day clock, so that's a little bit different. And we do encourage applicants to follow up with the tribe to confirm receipt of the packages. And when you do that, we ask that you communicate that follow-up, it's a courtesy and it's not indicating that you're late in the process. It's just a follow-up from the original clock, the original timeline being set. Okay, next slide. So again, tribes have 30 calendar days to respond after the receiving the information, or 35 if by mail. If there is no response, the applicant can refer the matter to FCC for follow-up. And tribes that have not provided any reply should be referred in the TCNS system. Tribes that can't be referred in TCNS may be eligible for manual referral. But we do note that before you do that, you check to make sure that they don't have a no response equals no interest language in their details. So please check that before referring. When the FCC receives referrals, the FCC will follow up by sending a letter or an email requesting that the tribe respond within 15 calendar days if they are interested in participating in the review. If we don't get a response that way, the FCC attempts a follow-up call to the tribal TCNS contact. And if the tribal nation does not respond to the FCC within 15 calendar days, the applicant may move forward unless notified otherwise by the FCC. Next slide. Oh, this is where I am turning it over to Christine. Thank you, Christine.
Thanks. All right, so government-to-government consultation. So I will reiterate that tribes have a right to request government-to-government consultation during any point in the Section 106 process. When a tribe requests government-to-government consultation, all correspondence is relayed through FCC staff. And tribes may choose to re-engage, may choose to re-engage with applicants or consultants. And for clarity, FCC staff should be made aware when a tribe no longer wishes for a project to remain in government-to-government consultation. This has happened when a project has entered into government-to-government, and then at some point getting an email from an applicant or a consultant. And I'm like, why am I hearing from you? This is in government-to-government. They're like, oh no, they re-engaged. We're back to speaking with them. So if at any point a tribe decides to re-engage and we're out of that process, please let FCC staff know. So we're a lot less confused when we get an email. And also, so we have at the FCC, we have the Office of Native Affairs and Policy. And these staff members are not normally directly involved in the Section 106 process, and they are an available resource that tribes can go to in cases of higher sensitivity. Next slide. All right, so tribal review fees. So consistent with ACHP guidance, applicants are not legally obligated to pay upfront fees when providing tribal nations with the opportunity to comment on proposed facility deployments. Tribal nations remain free to request upfront fees, and applicants may, if they choose, voluntarily pay such fees. The parties must mutually agree on the terms of any compensation in advance. So just like you would with any other consultant, there has to be an agreement. If a tribe conditions its response on the receipt of upfront compensation, an applicant should explain that the RNO clarified that neither the ACHP nor the FCC require applicants to pay Section 106 review fees and reiterate the invitation to comment on the project. If the tribe does not comment by the end of the review period, the applicant may refer the tribe to the FCC as non-responsive. I will say if you do get the response that a tribe is requesting a review fee, that's not a cue to stop all communication with them. Please try to discuss the matter, get some clarification, and then, if needed, if the request doesn't square with our rules, please gently and kindly clarify that, and again, invite them to comment. But if you get that request, we ask that you don't just stop talking, because it's not helpful. Next slide. So consultant services. So an applicant may ask a tribal nation participating in Section 106 review to conduct surveys or perform other services for which a negotiated fee is appropriate. If the applicant and tribe cannot agree on a fee, the applicant may seek other means to fulfill its reasonable and good faith identification obligation on behalf of the FCC. The applicant is not presumed to be required to engage the services of any particular party to assist with identification, monitoring, or mitigation. But the applicant must, however, use a properly qualified consultant or contractor when expert services are required. With respects to identification and evaluation of historic properties and effects, the professional must generally meet the relevant Secretary of Interior professional qualification standards. So, in most cases, this is an archaeologist. Next slide. So, traditional knowledge may be required to assess the significance of above-ground features or to identify archaeological properties or to monitor construction. An agreement regarding compensable services is required before services are performed. And if an applicant and a tribe disagree on whether the applicant has met the good faith standard of identification, either party may ask the commission to decide whether the applicant's obligations have been satisfied. In the case of a dispute, the applicant will have the burden of substantiating its claim within 15 days, and then following this, the objecting party will have 15 days to make their case. Next slide. So under the NPA, tribal, religious, and cultural sites are treated differently from historic properties already identified by SHPOs or federal agencies. FCC licensees and those who are building for them are required to cooperate with the tribes to identify historic properties of religious or cultural significance. There are cases where this may require research by tribal members or TIPO staff. And FCC staff is more than happy to assist in clarifying requirements upon request. The RNO established a dispute resolution process to handle disagreements between applicants and tribes over what constitutes a reasonable and good faith identification effort. Next slide. So tribal historic properties are frequently not identified in SHPO records or listed in the National Register. So tribal participation in Section 106 reviews is critical, as Ellen had mentioned. They can occur anywhere, and and tribes indicate their areas of interest based on their history. The NPA allows tribes and SHPOs to request an expanded APE. Within our NPA, we have prescribed APEs, especially for visual effects. So if they want to expand upon that, it's completely okay for applicants and TIPOs to come to an agreement. You don't have to go to the FCC before doing that. That can be negotiated between the parties. Tribes that identify historic property of religious or cultural significance should be invited to become consulting parties. The FCC expects that the identification of a historic property of tribal significance will involve a recognized tribal authority. And in cases where site information is sensitive, the FCC can work with the tribe and applicant to develop an approach that avoids areas of religious or cultural significance. The FCC and our licensees do not need to know why a site has religious or cultural significance to a tribe. We understand this is sensitive information. We don't need to know the details. Next slide. So learning from TIPOs. Each tribe has a unique history and perspective that informs their evaluation of federal undertakings. And there are unique factors that TIPOs and their staff evaluate when considering impacts on tribal, religious, and cultural properties that are different from what the consultants may be used to when working with SHPOs. In some regions, large geographic areas have traditional meaning and continue to be actively used by the tribes. For some sites, knowledge about the importance of a place may be restricted to certain clans or families, and FCC staff do not require that tribes explain their religious and cultural beliefs, only that a recognized elder and/or tribal authority has identified the area is important. Next slide. So just some reminders. Only tribes can identify their historic properties of religious and cultural significance. Sites may include tribal cultural landscapes and traditional cultural properties. Traditionally trained archaeologists may not recognize evidence of tribal sites, and different tribes may view the same site differently. So there's a quote up there. So for example, an archaeological site can have culturally significant plants and modified trees above ground, peeled bark or coppiced or pruned to engage new growth, a lithic component underground, and possess a viewshed of an important cultural or spiritual location, such as a mountain. The complexity inherent in these types of places is understood by the communities that inhabit and interact with them. So that is very specialized knowledge that, a traditionally trained archaeologist, probably wouldn't have. And we, of course, remind people to protect the location of all tribal sites. And next slide. So you can email all general questions on tribal participation requirements to tcnshelp@fcc.gov. We also have the TCNS Help Support Team, Myra Delau, Connie Diaz, Leon Jackler, Don Johnson, and Matthew Hartnett, who are all excellent and very helpful, and they know all of these things backwards and forwards. So very useful contacts at the commission. Next slide. All right, and that's it. Questions?
Great, thank you, Ellen and Christine. Actually, we do not have any questions right now. Yeah. So I guess what we'll do is we're a little ahead, which is good, right? So I guess for those in the audience, we could take a break now and join a little bit earlier because our speaker is here for the TCNS portion. Or do you want to go jump into the TCNS portion right now and then do the break for the last one? I'm thinking we have a break now. What do you think? Okay, I'm getting some nods in agreement. Okay, why won't we come back at, let's say, 3:35. Does that work? Okay, great. Thank you. Okay, everyone. It's time to settle back in. Just a few more presentations for the afternoon. Okay. Thanks again, everyone, for returning. We're almost done for the day. Okay, thanks again, everyone. Everyone's all got their caffeinated now for the afternoon, energized for the next two panels. We're almost done. Okay, next, we're going to discuss the TCNS system and how to use the system to facilitate Section 106 communications with tribes. And presenting today, we have the privilege of Diane Dupart, Chief of the Technology Systems and Innovation Division of the Wireless Bureau. Diane is here from Gettysburg, Pennsylvania, so we're privileged to have her in person today. And thank you again, Diane, for coming. She's our IT expert here. So thank you again, Diane.
Oops. There. Okay. Okay. We're going to take a look at a couple of views of the different users of TCNS. And the first view is the applicant consultant view, and the options to submit a TCNS notification. And then we'll look at a couple of options the tribes have that might be of interest with respect to some of the things that you might see in some of the system notifications that you receive with tribal information. And then we'll show you the manual referral process. So first we're going to look, like I said, we're going to talk about the applicant or consultant view, how to submit a new filing, how to refer a notification, and look at some of the options to view the details of the information about the project that you submit into the system. So to submit a new notification, there's a link up in the left-hand corner of the landing page once you log in. And as Ellen and Christine have been talking about, there's two different kinds of projects. And we do give you an indicator, a box to check, to indicate that this project is excluded from SHPO review. You would enter the contact information for the consultant, the applicant, and then on this next page, you would enter the proposed structure data. And the required alternate submission packet is uploaded through an attachment utility, and there are other optional preset options to submit other types of documents that support the review of the project. Once you upload all of your attachments and your alternate submission packet, you continue to this next page, which is a summary page. And this allows you to look at everything you've submitted for the project. And you review that you've checked the box that it's an excluded project. You look at all the information you keyed into the first two screens. You have an opportunity to go back and edit the notification. You can go back and look at the attachments you uploaded, add other attachments, or delete ones you mistakenly added. Once you've verified all the data here, you can submit the notification. And if you forget to submit the alternate submission packet, the system does flag it for you and throws you this error, and it'll allow you to go back and upload that attachment, and you won't be able to submit your notification until that packet is uploaded. When the notification has been submitted, the system will assign a unique TCNS number to your project, and that number then is displayed here on your confirmation page. Each week, the system processes out all of the notifications submitted the prior 7 days. And there are two outputs that are generated each week for new notifications. And the first is the email or letter that goes to the tribe, and it's called the Weekly Notice of Tower Notification System Filings. And that notification then will provide the tribe a list of all of the projects with a summary of the details that you provided. Now, it doesn't provide them the attachments or maps or whatever you submitted. The tribe actually does have to log into the system to actually view those, the alternate submission packet and any other information that you uploaded. The other output for the week is the email back to the consultant or applicant with the list of the tribes that were notified about that project. This notice of organizations, which were sent proposed tower construction information email, is generated for each project that's submitted. So for each project you submit that week, you will get a separate email. And it will, like I said, it will list the tribes, their contact information, their preferred method of communication, and any additional details that they might want you to know about their consultation process. So just a couple of reminders for the projects that require a related 620 or 621. We want you to remind you that you should wait until you receive your notice of organizations email before you generate or start that 620 or 621 form in the system. The TCNS system does not populate or push the list of tribes to the E106 system until that final notice of organization email is generated. So if you start a 620 form or 621 form in E106, it will not populate that list of tribes. That's important in that application filing. The other important thing is that we cannot make any changes to the data you submitted on your TCNS filing. So if you have any incorrect information, we require you to go back into the system and update the status of that project to abandoned, which removes it from the tribal review process, and then you submit a new notification with the corrected information. Okay, we'll look at referring a notification. So projects that are excluded from SHPO review are made available for referral, and a refer this notification link will appear. The system tracks the 30-day consultation time period, and so when it's ready for referral on day 31, you'll see the link to refer the notification. Once you click on the refer to notification link, you'll be displayed with a list of all the tribes that were notified about your project. And any of the tribes who submitted a response through TCNS, there'll be a hyperlink for you to go to look at that if you need to again. And those tribes will not be available for referral, so you'll see no checkbox there. So any tribe that is available for referral, you can check the box and continue. So this is just your confirmation. At the same time, there's an immediate email that is generated that is sent to the email address of the consultants who submitted the original notification, confirming that your referral was submitted by the commission or received by the commission. Now, the TCNS also provides a way for you to refer a tribe to the FCC where the initial contact was not made through TCNS. And there's a link at the bottom that states refer notification where initial contact was not made through TCNS. This data entry process is two screens, and it's pretty much the same screens as a new notification where you provide the applicant and consultant contact information, the project information. You upload attachments or any other information that would assist the FCC in the review of the referral. And then the next screen requires you to enter the first contact date outside of TCNS with respect to that project to the tribes. And this allows us to verify that the initial 30 days was permitted, of consultation was permitted, or review was permitted by the tribe. Now, this is the confirmation page when the referral has been submitted. And TCNS processes referrals on a weekly basis on Thursdays. So, and there are two outputs when these referrals are processed. So there's an email or letter entitled Proposed Construction of Communications Facilities, Final Request for Indication of Interest. And the FCC sends this email or letter to a tribal nation or NHO after it receives a referral from the applicant. It is a request that the tribal nation or NHO inform the applicant and the commission within 15 calendar days of its interest or lack of interest in the participating process. The second output is the proposed construction of communications facilities notification of final contacts email that goes to the applicants. And following a referral, this email is sent to the from the FCC to the applicant to inform the applicant that the FCC has sent its final request to a tribal nation or NHO, and that if it does not respond to the FCC or the applicant within 15 calendar days, the applicant's pre-construction obligations are discharged with respect to that tribe or NHO. These couple of screens were examples of those emails. And again, they provide that same information that I just read to you, and the list of the notifications that were included in the referrals that were processed that week. Back on the homepage, the consultant or applicant has a way to view the notification details for their list of projects. Each of the notification ID numbers are hyperlinks. And when you click on that hyperlink, you see this detail, and it just regurgitates the information that was data entered on with the original notification filing. Now, this is the view of the notification details for a project that requires SHPO review. And so this will display the date that the Form 620 or 621 was made available. And it also lists the E106 file number. And that file number is a hyperlink that will take you over to the E106 system to look and view at that related E106 filing. So we'll take a look at a few of the options that tribes, THPOs, or NHOs have whenever they log into the TCNS. They have a different view of the system than you do, and each tribe has a unique login page. They can't see each other's notifications or projects that they're reviewing. Now, with the E106 notifications, when the related E106 notification is generated or submitted, the system generates an email or a letter to the tribe, and it will provide them information with regards to whether or not that project is subject to SHPO review. And it also calculates and provides them their tribal review end date. So whenever they receive this email, they know that with the submission of the 620 or 621, their 30 days starts, and we provide them a calculated date for their review period end date. So whenever they reply to a notification, they click this link from their homepage, and the system will display to them all of the notifications that they have pending that may have been referred to the FCC. So once a referral is processed, it is flagged that way in the system for the tribe whenever they log in to review and look at the pending projects that they need to review and respond to. Okay. When they click on the notification ID number, it's a hyperlink that goes to the details for the notification. And they see the same screen here and it provides them with all of the detailed information. It again gives them their tribal review period and date, whether or not it's a project that is excluded from SHPO review. It also has a link to view the attachments that were submitted. So when there is so when there is an alternate submission packet, whenever they click that view attachments link, it will take them to this utility where it enables them to download that alternate submission packet for review. So this is a notification detail page from the tribe's view where the project does require SHPO review, and it provides them the date that the notification was submitted, the Form 620 and 621 whenever they were made available, their tribal review end date, and then the related E106 file number. And again, that file number is a hyperlink to the actual Form 620 or 621 in the E106 system. So when a tribe has access to TCNS, they also have access to E106 to view and review the Form 620 or 621. Tribes also have a search option, and that allows them to pull back specific projects for review. And when they do a search, they have a results screen, and it displays some basic information, and it'll give them an icon letting them know that, oh, this project is excluded from SHPO review. Again, they click on the notification ID, and I lost the page. And they are able to see the notification details, view attachments, just like I said, in the same process and same manner they do when they were replying. You'll see that a lot of there are many tribes that will provide additional details with respect to their review and consultation process. So they have an option to enter that information in TCNS and submit it for FCC approval before it's actually put into the notice of organization's emails. So they enter the text and click continue. They get the summary page where they can review the information, make changes. And once they submit that, it becomes a status. They can see a status that it's pending FCC approval. So FCC staff reviews and approves the additional details on a daily basis. And the staff may reach out to discuss the contents of the additional details text before approving the new language. A tribe will receive an email once the FCC has approved the new or modified additional details. And this is just an example. Once approved by the FCC, the additional details, again, like I said, will be added to the notice of organization's emails to the applicants, providing that additional information. So lastly, we'll look at the overview of the TCNS manual referral process. If an applicant does not receive a timely response to its TCNS submission from a tribal nation or Native Hawaiian organization, the applicant may refer the matter to the FCC for follow-up. In most cases, the applicant can rely on an automated referral process via the TCNS system itself, but as we know, in some cases, the automated referral is unavailable and a manual referral must be submitted. The manual referral process is an online web form used to submit the data needed for FCC review, and it's located at this URL that Ellen referred to earlier. And the manual referral process relies on human processing by both the applicants and consultants and the commission staff. So accuracy and organization is critical to make it a success. So things to keep in mind prior to referring, applicants should ensure that the E106 filing commenced and the information was delivered by a preferred means, that the 30 or 35-day period for review is up and referrals become available on the 31st and 36th day, that the tribe did not provide a valid response to the project in TCNS, that the tribe has not indicated, no response equals no interest. A couple of things to note: that we don't want you to refer a tribe that has provided a specific or substantial response. A request for fees, however, is not considered a response. Further guidance about the substantial responses and fees is in the Q&A document on the Tower and Antenna Siting webpage. And when a tribe responds with such a reply within TCNS, automatic referrals through the system is not possible. So any reply that comes through TCNS from a tribe automatically eliminates them from being referred through TCNS. So you would have to then defer to doing this manual referral process. So this is the beginning of the web page. The web page is kind of a scrolling web page with data fields for entry of information. All of the red starred data fields are required fields. The name and email of the person referring the tribe, the TCNS number, whether or not SHPO review is required or not, the E106 number, if applicable, the project location, and then we provide a drop-down list to select the tribes that you are referring for that project. At the bottom of this webpage is a method of delivery that was requested by the tribes, and then the date that you sent the documentation that they may have requested. We also give you an opportunity to add additional comments and to upload attachments. Attachments are required with every submission, and the required attachments include copies of emails sent to tribes, proof of mailing or physical delivery to the tribes. Missing attachments will lead to the cancellation of your referral or delay the actual processing of the referral. Referrals that have been submitted by 11:59 each Tuesday will be included in that week's Thursday referral processing. So although this web form is outside of TCNS, we do have a way to import it into the TCNS system, into the referral processing, automatic processing procedure. So we also have TCNS help at fcc.gov. Okay, we also have ways to communicate with FCC staff with different issues with using the TCNS or E106 system. We have a customer support where you can actually call and ask a question or ask for help. Use of TCNS and E106 requires you to register with the FCC's CORS, the Commission Registration System, and receive an FCC registration number. And then that registration number has to be added to our system by a manual process that allows you, that then gives you access to the system. And to register for access to the system, you can either call our customer support system or submit an online help request at the URL listed here. Any other questions or concerns or help you need with respect to submitting a notification, referring a tribe, the E106 submissions for this Form 620 or 621 can also be sent to the TCNS help request as well. Questions?
Thanks, Diane. In regards to how the TCNS system works, we do not have any questions right now. In the future, if you do, I recommend you reach out to Diane's team through the email address and so forth. And if there are specific questions, specific cases and so forth, her team is extremely helpful. So thank you again, Diane. Mm-hmm. So, good news, we are ahead of time, but one of our panelists isn't quite ready, so we're going to take a 5-minute break. Apologize. Thank you. Okay. I think we're ready, you guys. 5 minutes goes by fast. Okay, our last panel. So I know 5 minutes goes by fast. Thank you, everyone, for gathering again. Okay, we've got our final panel, and we're thrilled to have guests here from the ACHP and NTIA. So ACHP is participating virtually, and NTIA is here in person. For this panel, I'm pleased to introduce Carrie Hicks, our Deputy Bureau Chief from the Wireless Telecommunications Bureau. She will moderate this panel and will introduce our panelists. Thank you, Carrie.
Thank you very much, Garnet, and thank you to everyone for sticking around for the end of the day. Really appreciate it. And I'll kick things off by introducing our panelists. At the table with me is Amanda Pereira, who is the Environmental Program Officer at NTIA, and Jill Springer, who you may remember as FCC's former FPO and as a policy advisor in the FCC's Office of Native Affairs and Policy before her starting her current role at NTIA as Senior Policy Advisor and NTIA's Chief Environmental Review and Permitting Officer. And we have two colleagues from the ACHP on teams. They're visible on that screen, but not this one. So there's Jamie Leushinger, Director of the Office of Federal Agency Programs, and Emily Choi, who serves as a Historic Preservation Specialist at the ACHP. On this panel, we're going to discuss how our agencies and other federal agencies work together on Section 106 reviews of communications projects, including sharing resources and leveraging program alternatives to eliminate duplication in the Section 106 review process and facilitate reviews. And then NTIA and ACHP are also going to share some updates on their agencies' activities that may be of interest to this group. Thank you very much to the panelists for joining me, and we'll jump in. So first, an important area of collaboration among our agencies and others who work on communications projects is the use of program alternatives, which are tools that can allow agencies to tailor or streamline the Section 106 review process for certain categories of actions or address instances when multiple agencies have responsibility for a project. For example, when a project is being built to support FCC licensed services, but also will be funded by another federal agency or located on federal lands. Following coordination efforts among all of our agencies and many others, the ACHP has issued multiple program alternatives related to the Section 106 process for communications projects. So Emily and Jamie, could you please explain those existing program alternatives that are available to our agencies involved in communications deployments, and also share any other updates that you'd like to share for this group? Thank you.
Sure. Happy to. And again, thank you for the opportunity to be with you all today. I'm sorry we couldn't be there in person, just one of those days, I guess. But we appreciate the chance to be with you all. I think we had just a brief slide presentation that I think you guys probably have queued up there
right.
at FCC. So hopefully that'll come up. There it is. All right. So as Carrie mentioned, I'm Jamie Leushinger. I'm the Director of the Office of Federal Agency Programs. I'm joined today by Emily Choi, who is our Historic Preservation Specialist who reviews FCC cases. So we'll go ahead and go to the next slide, which is really just an overview, just a quick reminder of who the ACHP is. Obviously, Emily and I are some of the professional support staff. The council itself consists of 24 statutorily designated members. We have a full-time chair, we have a vice chair, members of the public, expert members, federal agencies, meant to show kind of the breadth of the preservation interest throughout the country. Our primary responsibility is to provide recommendations regarding preservation to the President, Congress, and heads of other federal agencies on a variety of topics that intersect with historic preservation. Right now, we recently passed a climate change policy statement. We're working on one that should hopefully be released shortly on housing and how that relates to preservation. We put out a lot of information on Indigenous issues, particularly Indigenous knowledge and how that relates to historic preservation. We're also a member of the Federal Permitting Improvement Steering Council, so really working across the entire federal government to make environmental reviews as efficient as possible. At a staff level, Emily and I, we primarily oversee the implementation of Section 106, and we assist agencies in developing compliance strategies. We spend a lot of our time doing training, so that link on the website there takes you to all of our 106 courses, webinars, guidance, the whole shebang. So. But on the next slide, what you'll see is, kind of the program alternatives as they relate to broadband. So I'll go ahead and turn it over to Emily for just a quick overview of the two types that are in effect here.
Great, thank you, Jamie. So there are several program alternatives available for broadband. And before we go over them specifically one by one, I'm going to give you a very, very broad overview of the two types of program alternatives that are available for broadband, and also share some helpful resources. So as you may or should be aware, there are two nationwide programmatic agreements and two program comments addressing broadband infrastructure. And so first, what is a programmatic agreement? Programmatic agreements are the most commonly used program alternative. The scope of I'll call it a PA because that's just what I'm used to. The scope of a PA ranges from project-wide to statewide to nationwide. And really, at any scope, it allows the agency to tailor certain elements of Section 106 review to best fit the agency's specific circumstances. And the terms of a PA are negotiated between the federal agency, the appropriate SHPO and or TIPO, or SHPOs and or TIPOs, and of course the ACHP when we are invited or we decide to participate. And PAs can allow agencies to delegate certain decision-making responsibilities to non-federal parties, which happens in the FCC and PAs. So what is a program comment? And this type of program alternative allows a federal agency to request to the ACHP to comment on a category of undertakings rather than commenting on a one-by-one, project-by-project basis. So program comments are especially advantageous for agencies that have a repetitive management actions for a large inventory of similar historic properties, or for agencies that generate a large number of similar undertakings, which then generate a consistent and predictable set of effects. So in this way, program comments can help agencies achieve a broader perspective in planning for similar historic properties that it manages on a nationwide basis. And essentially, it really allows for a conversation at the national level to balance historic preservation values with other important public values and missions. And so on the presentation, on the screen, you can see 3 links. The first is on program alternatives generally, which goes into detail about each type of program alternative available, and also lists some in effect current example, which was great. And then you see the broadband N106. There are underscores between the words. And this link provides a great overview of the various efficiencies coming about from the broadband program alternatives, as well as a summary on the interagency collaboration that led to these agreements. And finally, we have a link to various resources and recommendations when it comes to early coordination and consultation with tribes on federal infrastructure projects. And I'll hand things back to Jamie.
All right, so then I'm just speaking broadly for broadband. It is one of the most covered sectors by program alternatives. That's not to say there still isn't work that we're doing on them, but it's pretty widely covered, especially compared to other sectors such as mining or transmission lines. So not to say that we're not exploring program alternatives there too. So the first one that we'll start with, of course, is the big nationwide PA for telecommunications projects executed back in 2004. So it's almost, getting to that 20-year mark. It applies to the construction of towers and antenna structures. It was most interesting just going back and looking at the numbers for 2022 to give you some sort of scale here. Almost 17,000 undertakings were reviewed under that PA. It does include co-locations, which is the other nationwide PA, but still that's a fairly large number when you look at the number of projects that are occurring across the country. So going to that point that Emily had made just a moment ago about using the nationwide PA to tailor the 106 process, what is tailored here is particularly the level of consultation, and then it also sets kind of the identification effort, your area of potential effect, and what constitutes a reasonable and good faith effort to identify historic properties. It also tailors the assessment of effects when those are identified. On the next slide, you see the nationwide PA for co-locations of wireless antennas. It was originally executed in 2001. It applies to the co-location of equipment, and it was intended to promote the use of co-location rather than construction of new towers. You know, that new towers can be more environmentally disruptive, but comparatively speaking, of course. So really, this was meant to kind of encourage the use of co-location. Most recently, it was corrected to, or it was amended to correct some unintentional inconsistencies. Sorry, I'm lisping badly today, but to fix some of the inconsistencies between the two nationwide PAs as they related, particularly to removing some of the co-locations from further review under Section 106. One of the other things that's interesting about nationwide PAs or any PA is being able to also take activities out of further review. So the idea that you don't have to review every single thing, that through the consultation process, you can identify certain activities that either don't require further review or don't require further review when certain conditions are met. So this was particularly advantageous for co-locations. So on the next slide, you'll see the first of the two program comments. The first one here is a program comment to avoid duplicative reviews for wireless communication facilities. It was meant to basically eliminate two reviews being done when an agency may be proposing a project, but then the FCC would also be reviewing it under their rules. So this program comment allowed us to kind of take away that duplicative review. It was originally approved in 2009. It's been amended a couple of times since then, mostly to expand the agencies that it can apply to. So we've added agencies as other agencies have gotten into the wireless communications game, which we seem to be seeing new ones every day. But so we added some additional federal agencies in each of those. And then we also extended the duration of this particular program comment to September 30th, 2025. We also, this was a very minor technical amendment, but interesting for us who work at the council, was that this particular program comment can be amended by the chair rather than being voted on by our full membership, all 24 members. So it's a fairly narrow technical amendment ability. It's really just to add other agencies or to extend the duration, but that does make it a little bit easier for us at the ACHP to move these things forward in an expeditious way. The other program comment on the next slide is the program comment for communications projects on federal lands and property. It was approved back in 2017. It was developed to, expedite the reviews and implement efficiencies for the deployment of broadband infrastructure on federal lands and federal properties. And originally, Jill was actually one of the main original staffers on it. I was not. I was an ACHP staffer at the time, but I wasn't participating in the consultation effort to develop this particular program alternative. But it had originally started off as a standard treatment, which is a different program alternative under our regulations. Through some of the consultation process, it was determined that that really wasn't going to fit or it wasn't the best fit for kind of obtaining all these efficiencies, because really what the agencies were also interested in doing is incorporating some of the provisions from those two nationwide programmatic agreements. So, the program comment allowed those to be incorporated into the process here. But much like some of the other, tailoring efforts, it does tailor the identification effort for a variety of communications projects. Unlike some of the other ones, it's actually separated out by the type of communication project. So you can kind of go to that particular section of the program comment to figure out what that process would be. We're actually in the process of considering an amendment to expand the program comment scope beyond federal lands and properties. We're considering actually an amendment that would expand its scope to any federal agency, regardless of federal lands, federal buildings, but any federal agency that has a communications project that meets the terms of the program comment. If the amendment goes forward, it would let them choose this as a compliance strategy for their telecommunications projects. There is an FAQ on this one. That's the last link that you'll see on the bottom of the screen there. It is helpful because it gives a little bit more information about how this particular program comment was developed. It gives a good overview of how it works. Obviously, if the amendment goes forward, we will be, updating those FAQs and probably creating a whole slew of other additional information to guide federal agencies as they implement this particular program comment. I'll go ahead and turn it over to Emily here to just provide, it wasn't exactly asked for this particular panel, but we did think it would be useful to at least provide kind of an overview of our staff level observations. So on the next slide, there's some good points to just kind of recall. So I'll turn it over to Emily to kind of provide her staff level observations of FCC undertakings as they come into the ACHP.
Thank you, Jamie. So in terms of the adverse effect notifications we receive, we are seeing less than a 10% participation rate, which is great. So I'll backtrack here a little bit and just go over the Appendix A criteria, which denotes when ACHP may participate. So that's a may, not a must. It's on our discretion. So these criteria include 1, substantial impacts on important historic properties. 2, presents important questions of policy or interpretation. 3, there's a potential for procedural problems. Or 4, issues of concern to Indian tribes or Native Hawaiian organizations. So when it comes to FCC undertakings, the most common adverse effect we see by far tends to be visual impacts to nearby properties or districts, or from nearby properties or districts. And I think this number percentage, is quite telling because it illustrates for me the efficiencies that have been created by, the nationwide programmatic agreement. And, just briefly, as for what I hear from consulting parties, I'll separate broadly into what consulting parties find challenging about the MPA process and what they, appreciate. So first, what consulting parties often find challenging would be the initiation of the consultation. And I'll unpack this a little bit. So depending on, location, region, project, what have you, consulting parties can have a difficult time finding out about the initiation of consultation. And also many are very unfamiliar with how to become involved as a consulting party under Section 106 specifically. And relatedly, consulting parties can also find lapses in consultation quite confusing or even troubling. So it's a very good practice to keep on top of communication, even when for 2 to 3 months there won't be an update. Just update them on that. So the other thing is consulting parties often want direct involvement by the federal agency, but are unsure of what they need to quote unquote show in terms of documentation or rationale, and in order to receive technical assistance from the agency itself. And finally, consulting parties really want to be part of the discussion early on. They often find that they're able to provide input after an adverse effect determination is made, which is already step 3 of an overall 4-step process of 106. So it's very important to allow for a full consideration of available alternatives and allow consulting parties to comment on that full consideration. And to close, what consulting parties appreciate. Consulting parties do appreciate receiving thorough and reasoned responses from the FCC on contentious issues or consultations, as they have been. And most importantly, consulting parties want consistency of process, consistency in when and how they can participate and provide input, and not a predictable result, per se.
And I guess I would just kind of close by adding here, that's not necessarily unique to FCC totally. These are certainly things that Emily and I see, as far as what consulting parties find challenging and what they appreciate. I would say that's just across the board. These are good practices, or these are observations that would apply to almost any agency, particularly assistance agencies, where, the agency is providing a license or a grant, a permit, where sometimes the local environmental process can really get ahead of the federal review process. And then just last, I would just offer that, a lot of our work that we do at the ACHP within the 106 arena, we don't often formally participate. About 90% of the FCC's adverse effect notifications we don't participate in. So 10% doesn't really seem like that much. Of course, you spread that out over all the other federal agencies, it's still a lot. Emily and I are to about 20 people who do these reviews in the Office of Federal Agency Programs. So really, we rely on our technical assistance capabilities and the regulations. So while we're not formally participating, we're often at consultation meetings or reviewing drafts or providing guidance over the phone or an email to basically help consulting parties, to help agencies, tribes, whomever, to navigate through the process and to offer some assistance there. So technical assistance really is where I would say, in some instances, more than 50% of our time really is spent on that technical assistance side. So just on the last slide is our contact information and our website. So Emily is the staff point of contact for FCC questions, but I'm always available as well. And if you are ever in person, feel free to stop by the Building Museum there in Washington, D.C. Despite today being virtual, we usually are there. So with that, Carrie, I'll go ahead and turn it back over to you, and thank you all again.
Thank you very much, Emily and Jamie, and thank you in particular for sharing those observations. It's very helpful, and also for talking about, of course, those program alternatives that have been really important tools for our agencies to collaborate and to streamline and simplify the review, both for the agencies and for other external stakeholders. And regarding the consulting party point that you raised, I would just note we actually recently put an FAQ for consulting parties on our tower and antenna siting page, which hopefully should help address some questions that consulting parties often have in the process. So next, we thought it would be of interest to this group to discuss how the FCC and NTIA are working together to leverage FCC's TCNS system, which you've heard a lot about today, to support NTIA grant programs. By way of background, the FCC and NTIA entered into an agreement in fall of 2021 to allow NTIA to use the TCNS system to notify tribes of NTIA-funded projects. And this process builds on the successes of past FCC efforts to assist NTIA in meeting its Section 106 tribal outreach obligations for the BTOP, or Broadband Technology Opportunities Program, back in 2009. At that time, the FCC and NTIA entered into another agreement to enable NTIA to use the TCNS system to complete Section 106 reviews and rapidly award those BTOP grants to support broadband deployments to unserved and underserved areas, including on tribal lands. So in 2021, the FCC and NTIA resumed that effort to allow NTIA to use the system again. So Jill and Amanda, I'd like to turn it over to you to please provide an update about NTIA's multiple funding programs, where each of those programs is in the process, and also if you could share a bit more about how NTIA is using the TCNS system to contact tribes about those funded projects. Thank you.
Thanks, Carrie. I think we have some slides. I'm not sure. There they are. That's great. So I just want to, before we jump into the slides, which are give an overview of the grant programs, just listening to Emily and Jamie talk about all of these program alternatives and thinking about TCNS, I have to note that I'm actually back at Department of Commerce and NTIA, and I was originally, the way that I started collaborating with the FCC was during my time at BTOP. And I just want to note, we do have a lot of program alternatives that build off, I think, the FCC's initiative in pursuing the original nationwide programmatic agreement, and also initiative when the Recovery Act broadband grants were proposed in becoming sort of a part of three agencies, the Rural Utility Service and NTIA and the FCC. Steve Del Sordo and Laura Dean and I worked very collaboratively, and I think it's something that maybe might be a little bit unique about communications agencies, because as historic preservation professionals working for a federal agency, I think when you work in the communication space, you really feel how important it is, the work that you're doing to make sure that people can communicate, and particularly post-pandemic, this initiative of Internet for All is just so important. But that first agreement that FCC extended to RUS and NTIA to use TCNS to make sure that tribes had the opportunity to comment on these
programs and projects that were serving rural and underserved areas kind of led to the broadband program comment that removed duplicative reviews, deferring to the FCC's NPA because it was a program alternative that had a history of working. And I guess I would just add to that, the way that the Broadband on Federal Lands program comment evolved actually was post-Recovery Act. One of the things, I mean, basically the Obama administration said what worked well and what didn't work well, and they recognized that the Advisory Council had done a lot with the broadband program comment to try to streamline Section 106. And so the federal preservation officers at the time, the ACHP worked very closely for 2 years between 2015 and 2017 to develop the Broadband on Federal Land program comment based on the experiences that we had with hundreds of Section 106 reviews for BTOP and BIP grants. BIP was the RUS program that was funding grants and loans similarly to BTOP. And so I say that to say that NTIA and asking the Advisory Council to consider amending the Broadband on Federal Lands program comment is kind of the progression of that work, and that work together, 3 agencies together, at another moment now with these Internet for All grants, where we see an initiative to make sure that everyone can be not only connected, but connected at sufficient speeds that they can go to school and telemedicine and do all the things we want to do. So that said, I will jump into the slides now. Okay, next slide. This is, Carrie already introduced us, but I'm Jill Springer, and Amanda Pereira heads up our Environmental and Historic Preservation team as the Environmental Program Officer. I'm a policy advisor on permitting and also the Chief Environmental Review and Permitting Officer. So next slide. So just as an overview right now, we thought that we had a big challenge back during the Recovery Act with, I think NTIA had $4 or $5 billion and RUS had $7 billion. Right now, NTIA has more than $48 billion in grants that will fund infrastructure to ensure Internet for All. And so the largest of those programs we'll talk about in a minute, the BEAD program, but the Middle Mile Deployment Grant Program is a $1 billion program bringing infrastructure to various communities. The Tribal Broadband Connectivity Program, a total of $3 billion promoting broadband on tribal lands. Broadband Infrastructure Program is grants to covered partnerships, states, and ISPs funded at $288 million. And then 2 programs that don't have significant infrastructure, the Digital Equity Act programs and Connecting Minority Communities programs. So next slide, please. So the BEAD program, the largest of them all, for $42.45 billion. And this program is funding projects in every state and territory, and it is allocations were made based on the mapping that the FCC has done, identifying unserved and underserved areas. This is a project that is right now kind of in the planning phases. Right now, states and territories are developing initial proposals. Those initial proposals over the next year or so will turn into final proposals and lead into a 4-year implementation cycle. So next slide, please. So BEAD, as you can see, is in the planning grants have been awarded, accepting initial proposals. There are a number of the other infrastructure programs, however, where awards are already funded, and these reviews for NEPA and 106 and permit applications have already begun. So next slide. This map is kind of interesting. I find it overwhelming a little bit in the scope of the effort that Amanda and I are responsible for supporting, but you can see here that these grants are impacting every state and every territory, and the good news is that means that it will bring infrastructure and communications at higher speeds in areas where there's some infrastructure already. Next slide. So this is a very conceptual graph that we have done based on the programs that NTIA is administering and where they are at the moment. You can see the dotted line is today. When we talk about permit applications, we're talking about permitting in the context of the approvals that NTIA will be responsible for NEPA and Section 106 review, as well as more real estate related permits that will be required when these projects are proposing to cross federal lands, for example, or to cross tribal lands, or will otherwise require easements or approvals from state, local, and in some cases, private entities. So beginning this year, fiscal year '24, we're anticipating that the number of these permit applications will begin to increase, and we see a very busy fiscal year 26 to 28 in terms of supporting the eligible entities, the states and territories, in implementing their projects. Next slide. So with this big challenge in front of us, we are taking a number of steps. We have an interagency broadband permitting coordination strategy, and we've been working beyond just the FCC, RUS, ACHP. We're working with a number of federal stakeholders on various initiatives, including interagency agreements. We have a memorandum of understanding with the Bureau of Indian Affairs and are working with a number of other agencies to establish agreements that will streamline reviews and remove duplicative responsibilities. We have been engaging within the 7 regions that BEAD is divided into with federal land managing and permitting agencies to make sure that they understand what these programs are and what the expected timeline is, where they may see surges in broadband permit applications. As Jamie and Emily have mentioned, we are working and continue to work with the Advisory Council on initiatives like potentially assisting them and supporting them and considering amending the Broadband on Federal Lands program comment. Because the allocations for BEAD came about through a mapping initiative. NTIA has a number of mapping resources that we are developing. We have a national broadband availability map that we have been kind of expanding to create other tools. So we've taken the base FCC map and overlaid federal land boundaries to provide heat maps and to work with federal land managing agencies to understand where we believe that infrastructure will need to be constructed that will trigger permit applications so that those agencies can prepare that they will be seeing those applications within that fiscal year 24 to 28 time frame. So those agency heat map reports are one tool. We also have been incorporating a number of GIS layers to allow the NBAM to be used by recipients and eligible entities to identify when they're plotting their linear projects, fiber projects, what are the other agencies that they're going to need to contact and consider in the permitting process. And then, very importantly, we're collaborating with the Federal Highway Administration. We know from BTOP, and we know just from talking with our various constituencies, that the vast majority of these grants will fund fiber, either buried fiber or aerial fiber. And so we are working with the Federal Highway Administration to talk about access to state DOT rights-of-way. And then, thank you, Amanda pointed out that we also have proposed categorical exclusions that are specific to the grant activities that we're anticipating, and that is right now under a final review by CEQ, and we anticipate hopefully being that initiative being completed in the next weeks. So our goal is to provide grant recipients with enough information and technical assistance necessary to optimize their success and to prepare our state, federal, and local partners for the surges in broadband permit applications. We seek to identify and address any potential issues early and to put these tools into place to streamline reviews, foster collaboration and ongoing communication, and then resolving project-specific problems at the earliest time and the lowest level possible. So next slide. I'm going to turn it over to Amanda to speak to the next two slides.
Thanks, Jill. So I'm going to take a moment to just at a high level go over what is involved in our environmental and historic preservation review process as it applies to the grant life cycle. NEPA and NHPA for grants are a little bit different because of when the federal agency is making a decision. So when we receive a grant application, we review those to determine if the grantee has provided enough information for us to clear the project. You know, can we apply a CADEX at that time is generally what we're looking for. So we find that those applications that provide useful project descriptions are ones that we can usually address most efficiently. For the BEAD program, we are still working out final details of what this is going to look like on the ground. But in general, for the remainder of our grant programs, this is how we process all of this. Some projects are able to be approved or cleared for EHP pre-award. The majority are not, and there's nothing wrong with that when you think about funding infrastructure projects. That makes a lot of sense. But where we can, we like to gain some efficiency there. We also strongly encourage that in the project planning process, before we even see an application, before we even have a federal action, that our grant applicants coordinate with land and resource managing agencies who may have an interest in their project. We encourage people to talk to their state historic preservation offices, and the goal of all of this is to avoid sensitive resources in the first place. That is the easiest way to streamline the environmental and historic preservation compliance process, avoid those resources in the first place. And we find that early coordination is one of the easiest and most successful ways to do that. For those projects that are not able to be cleared pre-award, we utilize a specific award condition that is a condition that is placed on the grant, and it withholds the majority of grant funds pending the completion of activities associated with environmental and historic preservation compliance. So that could be surveys, it could be developing an environmental assessment, things like that. And then what that allows them to do is post-award address those requirements. And that is something that we collaborate with them heavily on. We provide a lot of technical assistance, one-on-one, one-to-many. We do a lot of webinars. We have fact sheets, guidance, templates, and all of these things. And so it provides us with an opportunity to pause and take the hard look that we're required to for NEPA and NHPA compliance, as well as the other laws and executive orders that apply. We always strongly recommend that our grant applicants and then recipients engage the services of a qualified consulting firm, particularly when we are looking at anything to do with surveys, developing an environmental assessment, something where there are specific professional qualification standards that are required and specific expertise that comes to bear. Next slide, please. Okay. I think we back? Okay. So there are a lot of different factors that we like to discuss with our applicants and recipients that will help for successful planning. And really what we try to focus on is synchronization. And what we mean by that is just having an awareness of the different permits, the different approvals, all of the different things that may come into play in a single project. Because as we all know, it's very common for a single project to have involvement from multiple federal agencies who have independent obligations under NEPA, NHPA, et cetera. And so what we are trying to do as much as possible, and certainly with the new requirements under FRA, this is, it's taken best practices and made them requirements, is coordinate with our federal partners so that we can undergo one analytical process and then come out of that with a product that satisfies the requirements for multiple agencies. And the best way to do that is to have an awareness of timing. Is there going to be formal consultation required under the Endangered Species Act? You know, what kind of surveying might you need to do for, Section 106 issues in a given state? What will tribal consultation look like? So having some situational awareness of how all of these different factors will combine with each other, will intersect with each other, understanding dependencies. These are things that are really critical to providing successful project implementation for EHP issues. And again, we do find that one of our greatest factors in successful and efficient deployment is having that early coordination and discussion. Next slide, please.
So I think that we probably have gone over these either in the ACHP context or Carrie's review, but the TCNS system is one of the tools that we promote to our recipients. We actually do the initiations for those projects using a special interface that Diana and her team have set up. The various program comments for communications projects are important tools to our recipients. When those don't apply, obviously the ACHP's 36 CFR 800 subpart B section 106 review process it applies. And then finally, again, having mentioned that a lot of these projects are in state DOT rights of way, some state DOTs have minor project programmatic agreements that deal with broadband. And so we are working out how we're coordinating and can approach those duplicative review responsibilities in that case. Next slide. So as Amanda mentioned, we have a lot of different NEPA and permitting technical assistance, and it is on the Broadband USA website, should you need to access it. Next slide. So thank you.
All right. So I'm going to ask one question we received earlier that we thought was better suited for this panel. I think Amanda's and Jill's presentation covered this already a little bit, but we received a question about possible challenges with fulfilling the NEPA process, but while also meeting funding deadlines. So do you have any guidance to share on that front with how to work with NTIA on the process?
Well, I think we covered it, but do you have anything you want to add, Amanda?
I think one of the things that we find that takes people by surprise in terms of timeline is not being prepared to begin the NEPA and NHPA process upon award. And so we are dealing with timelines. We want to make sure that folks are successful in complying with the terms and conditions of their grant award, which includes the grant lifecycle. And so really being prepared to start having a clear understanding of where you're proposing things, what you're proposing, how it's going to look like, things that will allow you to start that NEPA process. That's a really critical element to helping, fit within that, because we generally find for these types of projects, most of them can be done very efficiently if they can start efficiently.
Thank you. And I'll ask one more question. So both Jamie and Jill talked a little bit about ACHP considering the amendment to expand the scope of the federal lands program, Broadband on Federal Lands program comment. So Jamie or Emily, could you briefly kind of explain what the next steps associated with considering an amendment might be and what that process looks like?
Sure. We're all going to figure it out together, gang. Unlike the other, I mentioned earlier that the other program comment does allow our chair to make some narrow technical amendments, to add on an agency or to extend the duration. That particular program comment actually just handed over the amendment provision to the chair. So one of the things that we've been talking about is finding a balance of what is reasonable consultation, because the amendment does require consultation with other federal agencies, the National Conference of State Historic Preservation Officers, the National Alliance of Tribal Historic Preservation Officers, the National Trust for Historic Preservation, and industry representatives. So we're crafting the consultation strategy right now. Those invitations should be going out actually next week. What we're putting together right now is that invitation. We've got calendar holds scheduled. As you can imagine, we're also trying to find an appropriate time to schedule these. This is about one of a dozen program alternatives currently in development. So, we're also mindful of not having multiple program alternative consultation meetings all in the same week. So we're, trying to space them out in such a way that it's still overwhelming, but everybody can meaningfully consult and offer their opinions on that. So, those invitations are going out next week for meetings in December ahead of the holidays. And then after that, we're holding in reserve the need to do a second round of consultation. Maybe a third. I don't think so. But we're gonna kind of just see what happens based on what we hear from other consulting parties. One of the interesting things about this particular program comment is that compared to the duplicative reviews program comment, this one isn't used as frequently. So to some extent, what we also had to plan for in developing these invitations and developing our materials was making sure people understood what the process contained within this program comment is. So there's a little bit of as a reminder, here's what this program comment does. And here's what we're looking to change going forward. So have certainly appreciated the chance to collaborate with Jill on that, given her, background with the program comment and, bringing Emily and some other staffers on to go through that consultation process should be interesting. But at a minimum, we're looking at consultation in December, with updates in January, as well as next steps, I would say, is kind of the current plan. I don't know if Jill wanted to add anything else to that.
Well, just one quick question, Jamie. If someone's listening in and is interested in participating or in that consultation, is there a opportunity for them to do so?
Sure. Absolutely. So one of the areas that Jill is actually going to assist with is sending that out to, and Jill, I'm going to get the name of it wrong, the State and Tribal Leaders Network?
State and Tribal Broadband Leaders Network.
All right, so that's where those invitations will be going out. So you'll probably see that coming from Jill direct, and she'll be forwarding that information on to those networks. And then, so there will be consultation meetings. There's also the opportunity to provide written comment. We're leaving it open. It might be easier for some folks to do verbal comments during the meeting versus written comments. So we are leaving that open. But those invitations will be going out Tuesday is the plan. Wednesday it might be instead, depending on how quickly I'm able to finish a couple of the other pieces of the invitation.
Jill, did you want to add anything else there?
I'm sure. I would just add that, so the reason that this is important to us is obviously we have a lot of broadband projects that will be happening in a short period of time in every single state and territory. And so one of the things that we think makes sense is having one set of rules so that everybody understands when you're proposing a broadband project in general, what's going to be required and how it's going to proceed. And I know, just to kind of build on, when we were back in the 2015 to 2017 timeframe, and there was consultation done before that program comment was passed, there was a lot of interest on the part of industry in trying to make sure that there was, just in general, things can be very different from state to state in terms of what's involved and, what an area of potential effects is, what is a required level of identification. And so we just feel like this is a great tool that is out there, that was developed collaboratively with all the federal agencies, federal preservation officers,
that the tribes had commented on, and state historic preservation officers back when it was originally adopted. So we feel like this is a great kind of building off point to ask that this now, at this moment, be expanded so that it can become even more useful and to help us do what we need to do to provide internet for all.
All right, thank you very much, everybody. Garnet, were there any questions you wanted to ask?
No, I don't think so.
Okay,
I think people got a little tired towards the end of the day.
Understandable. Well, I just want to thank all of our panelists for joining us here and for all of the collaboration and partnership that we have with you every day. So thank you very much.
Thanks, everybody.
Garnet, any closing remarks?
Yes, just as Carrie said, I want to thank everyone today for coming, those virtual, those in person, and also for our guests today as well. Amanda, Jill, thank you again. It's so nice to see Jill again and to meet Amanda, and also our colleagues at ACHP, Jamie and Emily, thank you for participating. It's always great to have your voice and your presence in our annual workshop. So thank you again. So that is it for the day. I hope everyone, took something from today, learned something. As I noted earlier today, the slides and the video will be available on our website. I know I saw a couple people taking pictures and everything. It will be available for you, don't worry. So in closing, again, thank you. I think my colleagues, I want to thank again for helping to organize this. It was, there was a lot that we put together for the slides and the organization of everything, and I want to thank all those. Christine, Heacock, Ellen, St. Ange, Connie, thank you so much. Myra in the back there, Susan, John Lockwood, thank you again. I really do appreciate it. It's a team effort to get this together, and we recognize the importance of getting this information out to the applicants, to the industry, so they understand their obligations and they meet their obligations, and everyone's in full compliance and minimizing adverse effects, no significant impacts to the environment. We're all on the same page here, and we just want to thank you again for taking these efforts to learn the rules and procedures so that your clients and yourself, everyone's in compliance. So thank you again. And one point of closure, I think there might be some folks gathering at the beer garden, just a block from here. I think they have an indoor tent area because it's pretty cold today. So, but have a cool beer in the tent, and they have heaters and so forth as well. So thank you again, everyone. Good night.